Hello everyone. Today with us Dr. Priyanka Agrawal, and she will deliver a talk on basics of IPR and patent filing system in India. Usually all the researchers, when they try to publish any papers, so the work should be novel and they publish the paper. They do not have much knowledge about the patent, and they thought that patent will take long time. So whether before publishing the work, if they will make patent, then they can't publish their work. They thought in this way, so that they are not willing to make the patent. So they don't have much knowledge about the patent. So today it will be immense pleasure to invite Dr. Priyanka Agrawal. She is an woman scientist, C 8th batch, and Nippon Typec coordinator. Currently, she is working as an assistant chemistry, DGM, Jabalpur. So, welcome to Dr. Priyanka Agrawal.
Thank you. Thank you, Dr. Harpan, for inviting me for this talk. And here I am sharing my presentation. Is it visible?
Yes.
Okay. So, as he has said about me that everything he has said about me, that presently I am working as an assistant chemist in the Directorate of Geology and Mining.
You can make it
great...
full screen, ma'am. You can make it full screen.
Is it visible now?
Yes. Yes. Now okay. It is fine. Yes.
Okay. So I'm working as assistant chemist in the Directorate of Geology and Mining, and it's my pleasure that he has invited me to share my knowledge on the IPR, and I'm hopeful that this presentation will be useful for the researchers in all the streams. They are willing, they are doing their research. So patent filing in a present day is equally important, or we can say the more benefit if they go for the patent filing rather than for the their research publications. So along with that, as he said that I am the DPERM TIFE coordinator. So being the women scientist, we have given, we can say, a task about that we should aware the people or researchers or the students, or we can say the industries, about the what is actually the intellectual property right. So there is a mission which is being run by the national, run by, we can say, the Indian Patent Office in the coordination with the their one unit that is called the NEPA, and its intention is the National Intellectual Property Awareness Mission. As we were the women scientists from the TIFAC, so there is a coordination between them. Then they are using us, they are trying to utilize our knowledge of the intellectual property to circulate, to create the awareness amongst the young, we can say the young students, or our, we can say, the researchers, to get benefit of this IPR awareness. So being a one part of it, I am sharing the slides for awareness of this program. So this is the one slide we generally use it, that why we are I'm here for this program. So this is the IPR awareness program under the National Intellectual Property Awareness Mission. And I would be happy to share with you that the yesterday was the World IP Day. Every year on the 26th of April, this day is celebrated. So we are lucky that the day after tomorrow, we could not manage time yesterday. So I would like to congratulate you all, or giving my, we can say, the warm wishes that we are the part of this World IP Day. And the theme of this, we can say, of this World IP Day was the Women and IP Accelerating Innovation and Creativity. Especially for the women's, there is a scheme also which is run by the, we can say, the TIFAC along with the Patent Facilitating Center, that they run a scholarship scheme, a one-year scheme. They will get the stipend, and they will be introduced, or will get, we can say, that the trend in all the aspects of the IPR along with the patent. So when we talk about the IPR, so what actually the IPR is? That is, that is, we can say that intellectual property is either it's an imagination, innovation, and the creativity. Is it a new thing? No, we cannot say. Here, this picture symbolizes that the evolution of the mankind is a very good example. That today we are reaching towards, we can say, the electronic era. So before that, how this changes are going on. So the we can say the creativity was in our mind. So we have to protect it in a certain way, in a legal way. So this picture is a very good, I think, symbolizes to understand the basics of the IPR. Along with that, it's not a new thing. We can say our early writing in Mesopotamia, Syrian astrolabe, Chinese hibiscus, we can say our Gutenberg printing presses, these are all existing in our, you can say, the nature. And we are aware with this from the years ago. So what it symbolizes that IPR is a nothing, a new thing. It is a very, we can say, the old, we can say the origin which was in our mind, which we are nowadays, we can say simply just the giving them the message that how our, we can say that the innovations were in the mind of our ancestors. Now the next thing, when we talk about this one, we can say by this intellectual property, what we are going to do. It is just like to protect our, we can say, the physical assets. Just like a bicycle, what we do, we just go for using a lock and key system. In a similar way, if you want to, we can say, the protect our intellectual property. So what could be the mode of it? So I'm just talking about that. What are the creative thoughts, inventions, innovative ideas are coming in the young minds, we can say, in the even in, we can say, the small children's, or even we can say the youngsters, even we can say the human beings who are not educated, they have some creativity in their mind. So nobody can stolen that. For the protection of that, this channel is very useful. That's why this awareness is very useful, that how we get the legally protected, legally, in a legal way, we can protect the creativity of our mind. These are the some pictures that some of our intellectual ideas is in our mind. If we are just going to talk with someone, so somebody will tell, oh, the same idea is in our mind. Another one will say, oh, this type of work I have already gone through. So to protect our, we can say, the intellectual, to our creativity, this channel is very useful, that the awareness of this intellectual property is required. So when we talk about the intellectual property, what are its types? So here in this intellectual property, we have patent, we have the copyright, we have the trademark. I think we all are aware with these terms, that the patent, copyright, trademark, industrial design, trade secrets, geographical indications, farmers and plant variety protection act. Then there could be the SCICILD, that is semiconductor integrated circuit layout designs. All these are the coming under in our intellectual property rights. Whenever we start my presentation, I generally ask a basic question. The intellectual property can be owned by. So we will be thinking that the person should be highly educated. He should be PhD. He should have the master's degree. He should be a learned person. But we can say simply here in this, what could be the answer for this? Any individual recognized person, only the government agencies, any individual or organizations, only the PhD holders and the faculty. So any person, any individual of this country, of this world is can be able to file to protect their intellectual. So we can say the education is not only the criteria for the protection of their creativity. Now, as I was telling you about that, the types of
means
IPR.
school students also, schools or in the colleges, they
Right,
can also,
right. They can also
if
be
they
get.
have some
They
innovative
can.
thoughts, they can also
Yeah.
file the
Yes.
patents.
They can also file because there is some we can say the sections in our Indian Patent Act, though are we can say the illiterate, that means the small kids and the children, and they have the idea. So under there you can say the guidance or under their legal entity, they are eligible to file their patent applications. Okay. So it is not restricted that the age criteria is not in case of the patent filing. Anybody is free to file a patent application. I will show you some of the examples that the small kids, they are having the patents in their name. Okay. So when we talk about the IPR, so this IPR is classified, as I say, in two forms: industrial property, and there is a copyright and related rights. So here in this industrial property, as I shown in my previous slides, some designs, patents, trademarks, they comes under our industrial properties. And the second one is our copyright and related rights. So broadly, it is classified in this way. So you can say the some of the designs. We are very much familiar with the, you can say the design of the Coca-Cola bottle, and you can say the Coca-Cola symbol. Some we can say for the medicines, we have the patents. Some you can say this type of torch. You can say the this mark or logo. Then there is a trademark. Then there are some specific, you can say the jewelry designs. Some we can see here the Kolhapuri chappals. Here we have some, you can say the literally our you can say the books, and here we have some plant varieties. So in this way we have categorized the our you can say the IPR types. Now again, patent, design, trademarks, geographical indications, copyright, semiconductor. So these are the forms of our industrial IPR. This one, when we talk about all the types, so this slides gives us a very good example that it covers maximum IPRs type. We are very much familiar with the Apple laptops, Apple phone mobiles. You can say their circuits, that the design. So here, all the different IPs in a single product. You can say that the LED display, which could be protected in which form? This could be protected in patent. The body of the laptop, which could be protected in a form of design. The sign, we can see that the Apple sign, and we can try to correlate with the deceptive signs of it. But whenever we see the logo, like the Apple is there, the mark is there, we will see that it is a quality product. So this gives us a recognition of this, you can say a brand recognition, we get it from this product. So here the manual itself of this, you can say the brand is covered, protected in a form of copyright. And the layout of, you can say the integrated circuit, that is SICL design. So these, I think the 4-5 types is covered in a just one type, that is we can say the Apple mobiles or Apple laptops, or we can say their integral part. So 5 types of IPR is covered in a one single example. So it's a very good example for, we can say, to tell us something, to give the example of what IPR is or the types of IPR.
So
Now,
this, I means that if a small thing also, if that will be innovation, means it suggests, as I'm thinking that that suggests that a small thing also, if one can be found some innovation, then they can also file as a patent. So
definitely,
so that
a
small
small thing.
things they joint, then they can make a laptop. So that all
Yes,
the part will be different patent. So means if a one, like they thought that no, that I don't have all the like a for complete setup I don't have, so I can't make a patent file. So that's not the true. But if a small part also they can develop
they can be,
some
yes,
something they can get newly, or in some innovation they did in a small part, that also they can make as
they can
patent.
pretend. They can be prevented in a form of a type of IPR.
Yes.
Okay. I can give you a very simple example of, you can say our U pin. We have seen a very small U pin, that is a paper clipping pin. So this was the invention was of, we can say, one of the notorious boy of a school. He was not very interested, keen in doing their study. So there was a story of which I have heard that he was trying to use this, you can say, the paper pin, and he was sitting in a, you can say, in a garden or a park, and he was trying to play with that, you can say, the pin. So while he was playing, unfortunately, the discovery of the U pin was, you can say that it is invented by him. and now he is having the patent for that. We know that the utility of this UPen is in our daily life. So as you were asking about that, the small things, yes, the very small creativity can be prevented or the protected, but they should have some, we can say, the societal benefit or societal utility. Under that situations, the things can be will be protected in form of different types of IPR. So this one we can say that the brain will have the resources. If you are putting our, you can say, the brain power, this results in a form of property, and this property will give them a legal right. We will give them an exclusive right, which prevents to other to use your creativity of mind. They will not be able to use that without your permissions. First, they have to take your permission to use your creative inventions. Okay. So, what is the importance and the significance? What we are doing, we are protecting our creativity, our innovations, our, we can say, the inventions. We are excluding others. That means preventing our inventions from others. They can be stolen. They will try to infringe it. They will try to copy it. They will try to commercialize it. So this legal protections we are getting to exclude others to prevent them for misusing of our inventions. And another way, if we are protecting our inventions, we'll have the various way we can utilize it. Even we try to commercialize it, or we can earn it for our country, for our society, for our benefit. We will have these channels. Okay. So here we can say to goddess Saraswati is gives us that to create your knowledge, to put some your efforts. But we are mingling here that the Saraswati with the Lakshmi is it's a commercialized way. So this is a two-way. How to be mixing that, you can see the creativity in a to commercialize. So this is again I will telling you that the utilization and its commercialization. So we can use it for our own use. We can franchise it. We'll have the Disney. We'll have the licenses or assign. Or even if we try, we can provide it just like a moral duty, or we feel that our invention is very good. So we can try to, even we can say, to charity it, or we can donate it to our society or to our country, that the invention is having utility for our country. So this is up to us that in which way we are trying to use it. Okay. There is again some sections that is during the COVID, you can say, the crisis. So most of the medicines, most of, you can say, our these vaccines, they were not be under the commercialized way. What we were doing to another country, that we were just going for the charity of it, that the others can be used over invented in our, you can say, the most of the pharmaceutical companies. So this is a way that whatever the mode is with us, or there are the certain legal rights to the country which is governed by to use your invention for the country or the benefit of the society. So there are certain, you can say, the licensing agreements or the licensing rights are associated with this. Again, one thing is that, as I said, that being the academicians will get the pride. But this, we can say, the IPR protections is giving us that not only you should feel a pride like academicians of having your inventions, but you should go for the commercializations. You should go for its brand value. You should earn and you should invest. Or when you are giving some in a legally way, you are showing your inventions, then this will be the cause for the new, you can say, the inventions, that your inventions will become the prior art for the others to utilize it, to get it converted into further innovative way. Now we are talking about now the one of the IPR, one of the type of IPR, that is patent. So as I said in earlier by some pictures that we are protecting it, whatever is in our mind, the creative mind, the inventions. So it is a legal document. Like we can say the protect our precious, simply we see the precious jewelries in the lockers. So even it is like a legal protection of our intellectual property. So a legal document giving the holder the exclusive intellectual property rights over a specific invention. Patents are an important element in encouraging innovation. So this simple way that we are going for the protection of our intellectual creativity. This is again when we have, it's just like a legal document. So it's an award for the inventor and the reward for the investors. Okay. So it's a document which describes the invention and creates a legal situation in which the invention can normally only be exploited with the authorizations. It is giving us the legal right to, you can say, to exploit it, but it in a legal way. Other can be used with your permission. So authorization of the owner of the patent. So a patent protects an invention and grants to the owner the exclusive rights to use his or invention for a limited period of a time. So once you get a patent protection for your invention, so it is for 20 years. Whenever we have the patent granted for your invention, so it is for the 20 years. And after that, it will be in a public domain. And there is a one misconception amongst the people that we are getting a globally or worldwide patent. It is not true. Patents, grant of patent is a, we can say, the territorial right. In a particular territory, you will get, if we are the India, we will have a right for our country. If you are in a USA, that you will get the legal right in that country. But at such, it is not you can say that we are getting a worldwide patent. No, this is not true. It is a territorial right to prevent your inventions, to protect your invention in a particular territory, and its tenure is of the 20 years from the date of filing of your application.
That 20, just one more time, that 20 years means when it will be granted after that 20 years, or when just we file?
No. From the date of filing till the grant. From the date of filing, will the date, you can say the 20 years will start from your the date of filing of this patent application.
One more thing, I think it is like it this the all that thing mainly comes to all the researchers. That's why they try to stop to make the patent. That was that actually usually that they know that it takes a lot of time. The process, exact process, they do not know. First of all, exact process of what they have to do, if they will get some innovative idea, if they got some innovative results or this, but how they will make it in this way. That first of all. That they should aware about this thing. And second, how much time actually it exactly takes. Suppose they will start, like if they want to publish a article that takes usually 3 months to 4 months, 2 months to 3 months, so but how much time usually it takes if someone want to file a patent?
That is a very good thing that initially there is in our mind that it is a time consuming process.
Yes.
So I will tell you one thing, it's not a time consuming process, because now that our the IPOs, they are providing us to channel for the expedited way of, you can say, the grant of this, you can say, the patent applications. Okay, we'll have the early publications, we'll have the early grant. So I can say if your invention is in a ready form, we can say if it is in an elementary form, then it will take a time. But if you are ready with your product, whatever is you are going to create, and you are ready with the product in a particular format, that is called the specification of it. If you are ready with it, then there is a very, we can say, I can say minimum. There are certain examples in the very, you can say, the short time the patents is granted. So I can say in just 6 months, if you want a very fast granting of your invention, so there are the channels, there are the routes, there are the form facilities that you can go for the fast grant, fast publication of your inventions. Okay, so it's, I can say,
but grant
but
also in 6 months possible.
yeah, it is also possible.
Okay.
It is also
And for
possible
filing
that you will have a granted
for filing.
If I say for the filing, I can say in just 7 to 15 days, your applications will be published. This is the first step. Okay, and if you go for the earliest,
very less time, but usually
very less time.
usually people knows that it takes as like as per my knowledge, I was also thinking during my PhD, I was thinking that it takes minimum 6 months for the filing purpose only. Then it takes
No,
2 to 3 years for grant. So that's why we try to know if we can publish the work. Who will wait for that? But if it's 7 to 15 days it takes, then it's very.
there's a one thing
That,
that you are ready with your invention, with your, you can say, the paperwork, then within 7 to 15 days, your applications will be published. For that, you have to pay the extra money.
oh,
Okay, that is a one
okay.
rule. This is one thing. But otherwise, the thing is that if you are ready with, if you are in initial stage, that is, you have just the abstract writing, that the idea is in your mind, and you just want to protect your idea first thing. Okay, so for that, you will have the 12 months of time. So first, when you have a heading that you are going to do your research in the so and so topic, that is, you have guided your research, that you can see the research scholar or any of the student who is thinking that he is going to prevent to prepare this particular, you can say, the device, or this particular, you can say, the medicine, or you can say the particular whatever is in their creative mind. So you will have the 12 months of time for that to you can say you have filed a complete specification. So in a just a provisional specification, we can say you can prevent your date, you are going to secure your date for that, that the inventions be in your name, because the same thing, you can say, that just after a minute somebody is having an idea of it, so your thought which is in your mind will become the prior art for the persons who have gone to the patent office for the filing of their application. So if some thought is coming in your mind, so you can go for the, you can say, for the securing of the date, you can file an application. And for that, you will have a 12 months of time. But if you are ready with your invention, then and there you can go for the publication. Otherwise, if you are just going for in a normal way, it will take, you can say, the 12, 18 months. But if we are going in a, you can say, the early publication way, so within a 7 or 15 days, as per the, you can say, the their publication time, you will get it in just 7 to 15 days of publication of your invention. And then time, if you go for the request of examinations, early request of examination, expedited way of the examinations, you will go for the your, as soon as your, you can say, the applications will be examined by the examiners, within after that the 6 months, if some, you can say, the objections are raised, some opposition is raised, if there is no oppositions, you will, applications will be granted after the examination within 6 months. So this I am telling you, the process fast routes are available, but you have to pay some extra money. But if your invention is new, we should go for that, you can say, the fast way of their grant. Okay,
And this
so the
patent
channels are
is
there.
always like it's always with a particular country, like for India or for US, for Canada, like that. That not
That
that
is,
worldwide. A patent filing always for a particular country.
it is initially, if we are in our country, in India, then we are going for filing a patent application. But we know that our invention is so innovative, it will have some, you can say, the utilizations for other countries also. So
The
there is a very good platform that is called the
PTC,
patent cooperation. Okay,
PTC file.
if you want to
So
file in some other country also, so you
okay.
can apply for the USP. You can say in the USA, you can go for in the European country, you can go in the Australian country, and all ever you can go in a single way. But there is a one platform which is provided, that is called, as I say, the WIPO is a World Intellectual Property Organizations. This WIPO has provided a channel that is called the PCT, Patent Cooperation Treaty, under which a single application we can file for a multiple countries. So this is again, we can say, the cost saving process, that you want that your inventions be useful for the USPTO, for the USA, or for, you can say, the European country. So there is a one thing that is called the PCT. We simply call it the PCT application. You want in a 2-3 countries, so it will be the cost, you can say, the cost effective process. Otherwise, if you are going for the USA, you will have to pay the, you can say, all the processing fee for the USPTO office fees process. If you are going for the, so you have to pay individually for other countries. But the PCT is a route which you're providing a common platform to protect your invention in the multiple countries. just you can say the payment will be a one-sided, and you will go for the legal protection of your invention in the whatever the country in which you find that the utility of your invention is. So this the PCT is a one route. So that's why I'm telling you it's not a world patent. We can say in our Indian Patent Act, there's a section that is called the 21M that defines what is a patent means. The patent means a patent for an invention granted under this act. Section 48 is talks about that the rights of patents. The person who is going to file the patent, and after till its applications, and you can say up to the examination state, it will be called a applicant. But once the invention is granted in their favor, then it will become the patent. So there are certain rights. For that, we can say doing this much hard work to get the patent. So what are the rights is governed under the section 48 of our Indian Patent Act is that where the subject matter of a patent is a product. It is for the two things, either for the product or for the process. So when the subject matter of the patent is a product, the exclusive right to prevent the third party who do not have his consent from the act of making, using, offering for sale, selling, or importing for other purposes that product in India. So this is the one kind of legal right a person who is becoming the patentee is governed under the law. The second one, where the subject matter of the patent is a process, the exclusive right to prevent the third parties who do not have his consent from the act of using the process and from the act of using, offering for sale, selling, or importing for those purposes that product obtained directly by that process in India. So when we go in a detail of our Indian Patent Act, we'll try to prepare something that we can say the meaning will be clear to you. In a general way, I'm just telling you that what are the rights we are getting, that the making, using, offering for sale, selling or importing, you are getting the protection for your invention for all such things. Next one, this is one thing we can say the format. This is the format which is mentioned in our third schedule, that if you are going to form of patent, this is how it looks like. And when this, you can see the certificate be governed by, you can see the patent office. So how the patent you can say the granted patent will look like. And here you will see that in this, you can see the certificate, you will have the patent number, your application number. As you were asking me that what is the date that I say that this the protection is for the 20 years. So you will see here in this that the date of filing, from the date of filing, you will get the protection for the 20 years, not from the date of grant. Because as I say, if you are going for the early route of, you can say the grant, then you are getting the protection for the 20 years. But somehow in some of the cases, there are some the legal, you can say the opposition is there, and you are getting for the late application for the processing for the examination, then it may take years. So under that conditions, you can say the life of your patent will be 15 years, be the 10 years, but it will be starts from your date of, you can say the file. Then first patent. When we talk about who was the person who got the first patent, so the architect and engineer, that is called the Filippo Brunelleschi. So the first recorded patent for an industrial invention was granted in 1421 in Florence of the, you can say the architect and the engineer Filippo Brunelleschi. The patent gave him a 3-year monopoly on a manufacturing of the barge with hoisting gear used to transport marble. So this is, we can say, for you can say a type of, you can say the wooden platform he is designed for, you can say the transport of the, you can say the goods. So this was the first person for his inventions was in 1421. Then as I'm just telling you some the points that it's a grant by the souvenir or the state to a person. It gives the exclusive right, and it is to stop others from making, using, exercise, vending, and importing an invention for a limited period. In exchange for disclosing, it is in a patent specification such that anyone having average skill in the art can reproduce the invention. So there is a one important thing. what is the another aspect that we are going to get the exclusive right, but somebody will we are providing our invention, somebody is just like a platform that they can use. So our invention should be, we can say, that the every, you can say, the skilled persons will be able to understand what we are going to discuss, or what we are trying to share in our inventions. So this is another criteria, that a person should will have some the benefit from your inventions to create some other new things. So right to exclude others for using your invention, or owners has a qualified right to use the invention. So these are the certain points which we can say we take it in a, you can say, that in a negative way. So generally we can say that patent rights is a negative rights, that it looks like that you are getting the exclusive rights, you are excluding others. But in a other way, in a legal way, you are giving someone the platform to do some new inventions. Okay. This is another one that we can say with reference to that in 1856, that is the George Alfred Deepening. He is having, you can say, by profession, he's a civil engineer. For his inventions, that is called an effective pankha pulling machine. So this is, we can say, that the first, sorry, this is the first Indian patent was for this persons, that is called the George Alfred Deepening, or you can say for making the yeah, their inventions for the effective pankha pulling machine. So this is one, we can say, it was in 1856. Another, we can say, the some of the famous inventions is with us: Thomas Alva Edison, you can say the Alexander Graham Bell, Wright brothers, Louis Pasteur, Alexander Fleming. These are our well-knowns, you can say, the scientists and the inventors for their well-known inventions for the photographs, telephone, aeroplane, you can say the rabies vaccination, and for the penicillin. So it is, we can say, in our history, that the inventions are very useful for us, not from the today, but for, consider, from the years. Again, we can say the Aryabhatta, Sir C.V. Raman inventions, we can say the Dr. APJ Abdul Kalam's inventions. They're all, we can say, we can say that these are our, you can say, the inventions for known inventions with us. That is for the invention of the zero. That is for the, you can say, the Nobel laureate, our physicist, Professor C.V. Raman, for their Raman effect. We can say the APJ Abdul Kalam for the missiles, and you can say the nuclear weapon programs. And here you will see that by, we can say, the Vinod Dham for their, you can say, the Intel Pentium chips. That is called the father of, you can say, that the Pentium chips. Okay. So again, those are the inventions with us. We are well known with these scientists and for their inventions. Another, we can say, the some famous Indian inventions. We can say this nano car, we'll have this, the hepatitis vaccine, and our Jaipur foot. So those, we can say that in case in the recent, we can say the last decades, these are the new inventions. We can say the patented inventions are here. Then here we can say, I was just telling you that the small things can also be patented. Here you can say that the designs of these bandages. Here we can say that now we can say some of the, you can say the these irons. These are the different forms, you can say, of this what we call it, this the pin, safety pins. We'll have the different designs of the pin. We can see the evolutions from this, the dialing mode of the telephones to our current mode. There's so many ways for with us. We can say this, you can say that this that the inventions from the beginning 1946 to 1999, the different modes of, we can say, the currently we get it in a form of the laptops. Here you can say the one can get a patent for, you can see, the products, for even some modifications from the designings, and you can see the motorbikes, or we can say the useful do of the things. So there are various, you can say, the things are patentable things is present in with us. We'll get it the motivated, we will get it some thoughts to do our, you can say, the to get more creativity by getting the, you can say, the knowledge from these inventions which are with us in a patented. These, we can say, the recent, you can say, the inventions, even for, you can say, the small kids, even you can say the bandage form of, we can say, the, and here you will see the different forms of, you can say, our drones, and these are, we can say, the chips. So these are the new, our, you can say, the patented inventions. Along with, I was just telling you about the invention of the telephone, electronic lamp, you can say for the medicines, for the Louis Pasteurs. So in the slides there, you can say the patent application numbers, or you can say the patent granted number is mentioned. Not only in our country, they will have, you can say maximum is in the, you can say the US patents, when they have filed their inventions in the, you can say the foreign countries. These for the penicillin, you can say for the sewing machine, for the television, for the medicine aspirins. These are all our patented inventions for, you can say these name of these scientists. Now, when we say that, again, I'm going to, you can say some of the basic points of it. What is the main purpose of a patent? We'll see that in some of the examples of some of the, you can say the our well-known inventions, previous inventions, which is very useful. Here in the previous slides, you will see the examples which I have mentioned is not for the only a human being. Those invention is for the society, for their country. So here is that the protection for the technological advance. We are going for the advancement of it. We can say from the big machine type of, you can say the that you can say the monitors we have towards the laptops, or in a form of, you can say the notebooks type. So the protection for technological advances, for that we get the idea. So there comes the two terms, invention or new invention. So though we have inventions, you can say the dialing mobile, that actually was a new invention. But what we will do some the technical modification over into it, that will become the invention. Okay. So an award for the disclosure of the creation of something new, as well as for the further development or refinement or existing. This is another thing, the main purpose of it. In short, through patent, progress in changing technologies find incentives to improve. Whatever we are doing for the, you can say the improvement of it, to provide the new things. So the new, you can say the new way or easy way, easy techniques for, you can say the mankind. Here, what can be, when we talk about, we say from the product, we can say for the process, we can say the some small things can be prevented. So what can be prevented? All process and products, as section 48 of patent act, it talks about that the process and product patent. So all process and products which are new, they are involving inventive steps and the capable of the industrial applications. So these are the three major points when we talk about that we are going to do for some, you can say the invention. So it should be new, it should involve the inventive step, or it should be capable of the industrial applications. So I think our previous slide has given us most of the, you can say the applications, industrial applications of the these inventions. And there is one thing not barred by the section 3 and section 4 of the Patent Act. The section 3 and the section 4 is a very important section of our Indian Patent Act, which talks about what cannot be protected, what cannot be, you can say the patented. Inventions should all, you can say in the sections, I'm in the present, you can say that the presentations, I'm not exploring. Some other presentation I will explore in detail about the section 3 and the section 4. But here one thing is that what is not prevented is maintained in the section 3 and the section 4. Then in case of the products includes the apparatus, devices, machines, and the chemical products. Okay. So this is in a way that invention, patentable subject matter, it should have the novelty, it should have some inventive steps, and should have the industrial applications. Whenever we are going to invent something, though have these criteria, then we can say that our invention is going to be patented. And if it is cleared, they can say the norms of the section 3 and section 4. Section 3 is all about, you can say the chemical things, you can say about our copyright, about, you can say the machines, you can say our medicine parts, you can say the plant varieties, everything is covered under section 3. And in the section 4 is about whatever the inventions which is related to our defense purposes or related to our atomic energy. If something is like that, will not be patented. So section 3 and section 4 is talks about what is not patentable. Okay. Here, there is a one thing, as in they say that it should have new, it should involve inventive step, and it should be capable of the industrial application. So this thing that in our Indian Patent Act, the section 21J, it talks about the invention means a new product or process involving an inventive step, and it is capable of the industrial application. And sorry, and it should be capable of, we can say, the industrial application. So an invention is a new solutions to a technical problem. So in a definition way, it is defined under section 21J. The second thing, new means invention should not be published in India or elsewhere. In prior public knowledge or prior public use within India, claimed before in any specification in India or elsewhere, then the new means will be successful, will be applicable. That what is the meaning of the new? It should not be published. If it is published, then in terms of, you can say that in IPR we call it the prior art. Okay. So the novelty is determined before inventive step because the creative contribution of the inventor can be assessed only by knowing the novel elements of the inventions. What is the novel feature of inventions? What we are going to claim in our inventions? So that is coming under this point. Then again, there is a section that is called the section 21ZA, which talk about the inventive steps, non-obviousness. So a feature of inventions that involve technical advance as compared to the existing knowledge. This having economic significance or both, and that make inventions not obvious to a person skilled in the art, which is not known to them. So this comes under the inventive steps. So as I said, the three criteria, it should be new, it should involve the inventive step, that is a non-obvious, and it should be capable of the industrial applications. If these criteria will be fulfilled, then you are going to protect or got the patent for your inventions. Another than industrial applications, then invention should be capable of being made or used in any industry to result some tangible technical results. These criteria we fulfill whenever we go for the inventions for its production. Now, again here, the some basic facts what we can take. As we say the patent, I said earlier that I said the patent is not a worldwide. We are not going to get the global patents. It's a territorial right. So an Indian patent will only give the owner rights within India and rights to stop others from the importing products into India. A foreign entity will not be able to get it your, you can say, the patent inventions. So this is giving is a legal right. No concept of international patent, which I said earlier. When a patent is granted, the applicant becomes the owner of the patent. Applicant means which, when get the patent granted, it becomes a patentee. But it is, you can say, the becomes the owner of the patent. Like any other form of a property, a patent can be bought or sold. We can sold it. If you are thinking that we have invented something, but we can sold it to some other who is going to get the, you can, by the way of the, you can say, the licensing, we can sold it, and we can, in a form of the royalty, we can sold it, and we can type so licensed or mortgages. These are the, we can say, the basic facts and some of the advantages of taking a patent rights. So novel patent rights are territorial, governed by respective national laws. Term is 20 years from the date of filing. Regulatory extensions available in the USA. In US, European, or some other, you can say, the Japanese patents. Monopoly against complete disclosure of invention. You will have your monopoly to against the complete disclosure of your invention. So these are some of the frameworks we get it from this patents. Now, again, benefits in form of revenue generation, in form of licensing, in form of assignments, in form of technology transfer, merge, acquisitions, IP auctions. These are, we can say, the sum of the benefits, which I think I've shown in some of my earlier slides also, that these are the way to get the we can say some the commercial, or you can say the economical benefits for our disclosure of our inventions. This could be in a
So
form
that
of the
revenue they can generate, that is true. That is a that is one of the most benefited. They will be benefited. They can
right.
earn money from this. Licensing means what type of like for this
Licensing
product?
means there is a one we can say the section in our Indian Patent Act where we can say the licensing means that after the 3 years of your patent grant of your patent, some other company who is thinking that you are not properly utilizing your patented inventions, that your invention is like that, but some of the you can say pharma country who will try to use your formula for that, so they you will licensing your inventions, they are under the terms and conditions. By taking some you can say the benefits from that, you can license in that you can use their invention under such terms and conditions. The manufacturing right, you can say the product forming rights, you can say the process, you can say you are selling your process to them. So this is the way that you can license your thing, and they will try to make the product from that, and that right will be given in a form of a license. This is the way of you can say the license. But the certain terms and conditions are where you can say the mention in our Indian Patent Act. So there is a you can say a big or you can say a little bit a
So
complicated topic
suppose
regarding that,
we have a granted patent and we want to
right?
suppose just sell someone for by taking money, some royalties, you just sell someone. So can we give
Hmm.
also the same thing to others? No, only one. Technology can be transferred to only one.
You want to say that we can so the licensing to other multiple licensing agreement. You want to say that?
Yes, yes. Multiple can I transfer to multiple
So there is a some you can say the
government condition.
limitations for that, and
Oh,
terms and conditions are there. That could be the mutual you can say the terms and conditions, and there could be some legal terms and conditions that are associated with that. And there is a one certain criteria is that you can say that somebody is going to approach you that you want to license that somebody is approaching for the license, that with due permission of the government, with the due permission of the controller will give them the right that you are not properly you are utilizing your invention, your patented invention. So somebody will approaching, so after the 3 years of the grants, this will be somebody will be you can say will have the right to approach to the controller, to approach to the you can say the patentee, that there are certain criteria is that in the particular territory your invention is not being the general requirement that will not be fulfilled. But after licensing something, you can say we have to borrow the same medicine from other country, which is very costly. But if we are licensing our inventions to some other persons, so they will be say the very easily or in a cheap way will be available for you can say the some of the deadly diseases, for the
yes,
cancer causing diseases. So that will be available to our country in a we can say very nominal or affordable ranges to it. So this is
yes,
the one criteria for that the government will take. If somebody is not interesting, then the government will take in their you can say the rights that you should license your invention to a particular company or the particular you can say the persons who is going for the applying for the licensing. So again for the benefit of the society which is going the licensing agreement will be signed between the two parties. Okay, so this is again a benefit for that. So there was a recent, a very good case study in the Kerala that about some of the, you can say the cancer causing medicine, some of the retired, you can say a woman who was suffering from a disease, but she is not able to get afford that medicines because of the whatever the you can say the pension she is getting, and the monthly you can say that medicinal consumption is costly, very costly, near about the 20-25,000 for that. So she is approached to the you can say that the government or the particular the territory that she want to get the licensing of that medicine, so she will be able to get it in a very affordable price. So some of the pharma country should be license this you can say the medicine, so they will be get it in a you can say a very nominal prices. So the case studies are many case studies are there for you can say the specifically for the medicines, right? We can say the donation, there is a one thing is a donation, donating of patent. So here there is a one more example for that. In the south, the person who has invented for their inventions for making some plastics and all that, and he used that inventions for making the road. that whatever the plastic waste material is that he has composting, or you can say by mixing and all that. So after that, he find that his invention is so useful for the society. So he has donated to the, you can say, the country, that anybody can use their patented inventions, because it is again for the benefit for the society. So this is another way one can go in a you can say in a don donate a patent. One can go for the licensing. One will try to sell it, will say no, I am not using, I can sell it. And another can buy the one of the thing is that we are preventing that the infringing. So somebody is if infringing you can get it again, that you can say the benefit, and or you can say whatever the loss you have gained by loss you have uh, uh, you are having when somebody is infringing invention. So you can file a case or suit for against him for the infringement, and from that whatever the, you can say, the recovery you can get it. There's another way for that, to prevent there's a channels for, you can say, the preventing our inventions from the infringements. Now, obtaining a patent, file application for patent. Now I've told you everything, that what could be the benefit of it, what are the basic facts of it, how to file it, what are the, we can say, the initially that the facts, like it should be new, should have the inventive stuff. Now coming of that, how to file it, where to file it, who can file it. Okay, so there's a one thing, everything, if you go for, you can say, the literature search, if you go for the, you can say, the our IPO websites, so, and if you go for book reading and all that, everything is available. So individual person at their own can file a patent application. But if you are having, you can say, the not well enough for the patent filing procedures, so there are some channels also, that is called a patent agent. The persons who has legally, you can say, the uh, uh, that right to help you to file your applications, what are the forms to be filed, how to approach in the jurisdictions, where to approach, what form is required at a time, how much fees to be paid, how to reply the about your the what are the queries is raised by the, you can say, the objection is raised by the, you can say, the controller, or the objection is raised by some of the third parties. So if you are not aware with that thing, so we can say the easy channel is that we can take the help of the patent agents. So that will become your application filing process is smooth. But that is not required. You can at your own, if you go through our IPO sites, there everything in a, you can say, mentioned over there, how to file, where to file. If you go for it, you can start your filing of that patent application. Was, but is that with one of the patent offices based on the territorial jurisdictions of the place of offices or the residence of the applicant, agents pay the required fee. Information concerning applications from details of the fee, one can go for our websites, that is www.ipindia.gov.in. We can go here, and every, you can say, in the patent sections, there are trademark sections, there are design sections, everything is available in our frequently asked questions sections. What are the little doubts regarding that, whatever I'm telling you in a question answer way is mentioned over there. So guidelines is available in the IPO websites, or for our, you can say, the easy route, we can opt for a hire or a patent agents. So here is a patent application filing. One thing is that what are the things required, or what are the steps in patent filing procedures. So first one, file an application for patent. This is the first step. Then the second will be, it's a formality check. Then it is going for the publication. Then we have to apply for the request for examination. Then the examination will happen. Then the examiners will give us the first state of objections, or it is called the first examination report. We have to go for the responses from the applicant. There could be the chances of the pre-grant oppositions. Then examination of the pre-grant opposition, consideration of the pre-grant oppositions. After that, what could be the judgment? We'll go for the grant of a patent. you will go for the renewal fee. Okay.
How one can file the patent? Generally, application how they can do.
And one should definitely file instead of, you can
Yes.
say, the research publications. The first priority they will be that they go for the protection of their, you can say, the invention in form of patent file. So here I'm starting that before that step, we were just talking about that the benefits about it. What were the, you can say, the three parameters that our invention should be new, should have the inventive staff, it should be capable of the industrial applications. We have taken those parameters about the patent. Now the question arises, now how to file a patent applications? Okay. So I was telling you that these are the certain steps that our application is there. When it goes to the, you can say, the when you file that your application, it will go for the formality check, that you can say the some the errors in a particular field, that you are from the chemistry background, or you are from the physics background, or you are from, you can say, the engineering background. So in a which particular stream you are filing for it. So these are the some formality checks will be there. After that, will have a time that is called the 18 months time will be required for the publication in a normal way. So it will go for the publication of it. Just like our research publications, when a patent applications get published, so from that day, you will have that your invention is secured in your name. Okay, it is not granted, but it is published in a form of, there will be a title of it. Then the abstract will define your that the technical field, what are the inventions, what are the, you can say, the process you are doing into it. So this will be a small, you can say, the write up about that. You will mention in that, you can say, the public sorry, in initial publication of it. Okay, it will be disclosed in that way. Your whole complete specification will not be disclosed over. Then when this public your applications will be published, you will go for the request for examination. So if we will not file a particular form for the request of examinations, your applications will not be examined. Actually, in a till will not be. There is a 40, it's a, we can say in a general way, the time limit is for the 48 months. But we can go for the expedited way of the examination also. That we have to pay extra fees, but we can go in a, we can opt for an expedited way of the route for the examination of our application. Then it will go for the examination. After the examinations, we'll have the first examination report. The examiners will give it. They will put some, you can say, that the objections they will raise regarding what are the, you can say, that what are the, you can say, the points missing in your applications, where you should go for the, you can say, the corrections into your inventions. They will simply will say that your invention is not patentable. They will give us some, you can say, the prior arts, because it is already published. They are not falling under the section 3 and section 4. So in this way, they will raise some issues regarding your application, that your invention is not being be granted due to some reasons. Then if you will have the genuine reply, the genuine, you can say, the answers, you will go for the response for that. For that, you will have a time limit of the 6 months. Then up to that stage, someone can go for the opposition also, in the pre-grant oppositions. When you get applications will be published, somebody, some third party or some other persons can go for the, you can say, the oppositions for that. That is called the pre-grant oppositions. Then examination of the, again you are going for the responses for that, that there is a, you can say, the some steps and the procedure for the legal procedure for the, you can say, the opposition procedure. If you overcome that procedures, you will go for the examination of the pre-grant oppositions. Then the consideration, again, you can say, the examiner controller will go for the consideration of your applications. Then after that, he found that there is no oppositions, your applications in a stage that it is crossed all the, you can say, the, or overcome all the, you can say, that the deficiencies in your applications, then he will say that your applications will be granted. And when it is granted, the time to time you have to pay the renewal fee till the 20 years. Okay, so there is a time for time at the time that after the completion of one financial year, you can go for the filing for the 5 years, 10 years, whatever the way. There's a various way for, you can say, the paying of your renewal fee. to take it your, you can say the patent, granted patent in an active mode. Now, first I will say that when we go for the filing of our patent applications, there is a two routes. One is called the provisional specifications and one is called the complete specifications. As I said, that you are in an idea stage. That invention is in your mind and you want to create it into it, but you want to secure the date, or you want to secure that this is the invention is in your mind. So we can go for the provisional specifications. So the securing the priority date, this is called the priority date, and this date will be the date for all over the country, the countries in which we will go for the world country will opt for filing, we can secure our date. May be filed as soon as patentable idea come in our mind. Whenever the idea is coming in our mind, we should approach the patent office to secure that your invention or the secure that date. Dissolve essential features of inventions. What are the essential features? We'll put it into that our, you can see the provisional specification. Patent is granted on complete specification only. If you are filing the patent provisional specifications, then you will have a grace period of the 12 months to file your complete specification. So within 12 months, if you will not file, you will not be able to file your complete specification. So one thing is that your applications will be abandoned. There's a one thing. But there's a one way you will request for the extension of some time, and this extension limit will be of the 6 months also, that the coming 6 months you will be complete your specification and you will be ready with inventions. So there's a one step that you will get an extension of the further of the 6 months to file your complete specifications. Even in that durations, if you will not be able to file that one, then your applications will be abandoned. So we can say that totally from the provisional specifications for applying some terms and conditions, you will have a time of, you can say, the 18 months. In a general way, it will be of the 12 months. But the 6 months extension, we will get it that due to some reasons, we will not be able to complete our specifications. So the time limit to file the complete specification is 12 months from provisional specifications, but we can opt, if we know that what is that our law is allow us, we can take the benefit of a further 6 months to complete our you can say the specification. Now, what are the basic elements of a patent? Whenever we see, so I will tell you, you should go for in our Google patents, or we'll see what a patent applications or a patent document looks like. So you will see that there are the some, you can say, what could be the, we call it that the basic elements, or we can say the elements of the complete patent specifications. So according to these, you can say the titles, we have to prepare a patent applications or a specification. So it should have a title. Now, what is the title of your invention? So when we are preparing a complete specification, there will be again a limitation. It should not be more than 15 words. Okay, some fancy words should not be the part of our title. So the details about it I will discuss in some other our you can say the lecture. But here it should have a title as a field of invention. As I said, the field of inventions, the background. What is the previously? As I said, the invention is about your the inventions you are going to claim. So there could be the background, the summary. There will be the small summary of your inventions. There will be, if your invention is having some of the, you can say the drawings. Generally, in some of the mechanical patents or in some of, we can say our chemical patents, will have some drawings, will have some chemical formulas. So there will be the brief descriptions of our drawing. Then after that, there will be the step is called the detailed descriptions. We'll have the detailed descriptions that what we have invented. These are the steps. After that, we'll have the abstract of our invention. And after that, we can say the heart of our, you can say that the patent application, that what we are going to claim, what is the novelty in our, you can say that the inventions. So what we are going to claim is a part of it. And after that, in a separate sheet, we'll attach the drawings. So these are the, we can say the elements. We will get it in a patent applications. Okay. Now, key elements in patent registration. Those were the elements. Patent first, we should go for the patent search. Then the complete specification, it is called the complete draft. our specification draft. When the draft is, when we have searched the patent, some patents we have searched, we'll have prepared our draft, we are ready with the draft, then we'll approach for the filing of it. Okay, and if we are not ready with our draft, we can go for the provisional specification. Then after the filing, there will be the publication and the examination
So
process.
I think like later we can make one also session like for the viewers. So how they can search this patent, like here patent search, how they can search. That is an also important thing, that how the like researchers or whoever invented it, but how he can able to search, he or she can search the patent in Google, that which one already published. So that is an, I think, also an important part. At the same time also, like already in your lecture you already given the site where they can able to see all these things in detail, but how they can download like that, that title, background, summary, all these things are mentioned, but where they can get this form, the application form, where they can get and how they can get it. So later in, not now, in later we can, like in from the Google itself, we will try to if you can show us in detail in a class, then it will be really helpful for everyone.
Definitely, will go in a separate
Uh,
sessions. Will we go
yes.
for the patent
So
search,
all
and
the
that will be really
yes, so
valuable.
I want to also clear all the viewers. So please subscribe this channel. So we will teach in detail that Dr. Priyanka Agrawal with us. She has a lot of like in detail knowledge about this patent filing and all. So she will explain us in detail, and she will also teach us how we can also file a patent and all in detail. It will be very helpful for everyone.
Definitely, Dr. Rappan will do it in a later
Yes,
session
yes, yes.
about this patent search.
So
Okay.
hands on practical, we can do. You can show us. Then it will be very helpful.
Yes, definitely,
Yes,
definitely.
yes,
Okay. So these were the steps, that the search, that the drafting, that the filing. Then we go for the publication and the examinations, and after that will be the our grant of patents. So these we can say the broadly I'm just telling you about. Okay, and the detail we'll take it in a separate sessions. Now, want to file patent application in India? What to do? So there are certain forms. Okay, so in a just one way, when we are ready either with our provisional specifications or with our complete specifications, and we are approaching. So what are the sets of, we can say, the forms we should file? So there is a form one. That one is called, in the form one, that is a, we will simply say the details of applications, applicant, fee needed to be paid. This is the form one, right? In the form 2, that will be the detail of the inventions. That means the form 2 is about our specification. That could be the provisional specification, or it could be our complete specifications. This will cover our title, background of inventions, field of inventions, particulars of the drawing in a brief descriptions of the drawing, brief descriptions of the inventions, detailed descriptions of the inventions, claims, abstract, and the drawing. For this particular form 2, there is no fee, because the fee will be paid for the for form 1, where we will
how
have
much
all the
fee
details
will be,
about.
usually how much fee they have to pay?
The fee is that is 1600 for a natural persons, for a individuals. But if it is for a, you can say, of an industry, or we can say some others, that is for the natural, some person it is a 1600. From, you can say, the industry or the corporation, it will be the 8000 rupees. Okay, so this is the fee structure for filing the form 1, and the form 2 will have the no fee. And if our specification is under 30 pages and with the 10 claims, then up to that limit there is no fee. But if our, you can say, the number of pages and the number of claims are increasing, so accordingly we have to pay the extra fees for that. Okay, so about that I will tell you that actually what is the fee. Fee should be paid for increasing the number of pages and the claims. Then there is a form number 3, which is the details of the foreign file. That is, one thing is that if you are going to file after the invention is filed in some other foreign country, so the details of the foreign filing for the similar inventions, have you filed or you are thinking to be filed, that details you have to be provided. So just a sort of information to the particular, that is a parent office, that your invention is already filed to some other country. You have to give a one statement in a form 3. Again, for this form, there is no fee. The form after that, the form number 5, the declaration as an inventorship.
On or 4, there is no form 4 or?
Form 4 is regarding some the fee form. So
Okay.
in a one stage, that is related to the some extension of time in the fee, which is not a, you can say, the important form in this section while we are going to filing this application. So form 1 is for that. Then you will go for the, this will describes will cover all the details about the application or the applicant. Then form 2, as I said, about the specification. Form 3 about that the foreign filing of your applications. Now then the form 5, here will declare that who is the inventor. So the declaration as to inventorship, we have to be mentioned in the form 5. Again, for this one, there is no fee. Okay. Then again, one form which is I have not mentioned, that is form number 9, which is an optional form. If we form the form 1, form 2, form 3, and 5, form 5, then up to that, it's okay. But if you go for early, if you are not filing that form, another form, then it will take, you can say, the 18 months for the time for the publication of your invention. But then if we want that our inventions be published in just week or just 15 days, then we will go for early publication. For that, it's not a mandatory. If you require that your inventions be published early, so you can go for that form, that is called the form number 9, for the early publication of your application. This is form number 5. For that, the fee is about 2,500 rupees. If you want your application be filed early. Then this is a form 18. This form 18 is that this show the request for examinations. Okay. So the request for examination, this shall be filed. The time limit for that is that shall be filed within 48 months from the earliest priority date. So the form, when we are filing the form 1, along with that, if you are filing the form 18, so you will have a time limit of the 48 months. But at a time, within 48 months, you can file. But if you want that your applications be examined, so at the time of filing the form 1, we can file the form number 18. Okay. So the request for examination shall be filed within 48 months from the earliest priority date, or that is the filing date. If not filed, applications deemed to be withdrawn. That means if you are not filing, that means it is withdrawn. But you will have a time limit of the 48 months, and after that, whatever the time will be taken by the, you can say, the patent office, that will be included. But again, for that, there will be again the expedited way of the examination also. We have to pay some extra fees. There is some requirement that you should be a natural person, you should have the Indian origins, you should have a startup, you should have a female inventor also. So you will have some, you can say, the, so you are a government organizations, you are a research institutes, you are the company which is coming under, you can say, the semi government organizations. So for all such, you can say, the organizations, there is a route, is called the expedited way of the examination. For that, we have to pay some the extra fee, and when we opt for that fee, for that, you can say, the expedited way, our applications will be, you can say, the examined very fast. Okay. So these are the, we can say, the mandatory forms is the form 1, form 2, form 3, form 5, and form 18. As I said, form number 9 is an optional form. If you want the if you want that the early publication or applications, we go for that. Otherwise, it will take our, it's a normal time. As I was telling you about that the fee. So as I said, that the form 1, which is for the natural person or for the small startup or small entity, is a fee is a 1,600. But if the other than the natural, if you are a company, the fee will be the 8,000 rupees. As I said, the form 2, is it visible?
Yes, yes,
Yes.
yes.
Yeah. So here is for form 2, as I said, that there is no fee up to the 30 pages and 10 claims, no fee up to 30 pages and 10 claims. Form 3 has no fee, Form 5 has no fee. If you are going for the Form 18, we have to pay, that is for the examination, 4,000 rupees, and the other company is there, the 20,000 rupees. So in a normal procedures for, you can say, the applications, for a normal person's initial stages is required of 5,600 rupees. And for, you can say, the company, this cost near about the 28,000. But if we opt for here the early publications or for the expedited way of the process, the fee will be increased. Well, all such things is mentioned in our the first schedule of the patent rules, which is amended. And for the more details, we can see the first schedule where the fee chart is mentioned. Filing procedure: the submission of hard copy in the appropriate patent office, not available for the patent agents. This can be filed there, and there will be the online filing, e-comprehensive filing through portal. This is a link for it. If you are going for that, so you should have a digital signatures for class 2 or class 3. This is, I'm telling you, when we are going to individually to file in a physical filing, or we can say the, or you can say the e-filing. So these are the two routes are there for the filing of patents. This I'm telling you, this is the one you can say the portal, that is a comprehensive e-filing portal. We have to register into that portal. We have to log in. We have to use our, you can say, the class 4, class 3 digital signature for that. And under this login process, we'll have the details of all the files, all the, you can say, the forms, which is required for the filing of our patent applications. This is, I was telling you that Form 18, that is for the exam, that is for the examination of our applications. So there is, who can opt for the expedited way of the examinations. If you are a small startup, that is defined, these startup, a small entity, what could be the turnover for it, what is the time limit for the a company to be a startup or the small entity, that is defined under that way. If you are a startup, if you are a small entity, applicant is a female who is a joint applicant with the other natural persons. If you have the departments of the government and other government establishments, we have India is a ISA, that is the International Search Authority, International Preliminary Examination Authority in the PCT. An agreement between the Indian Patent Office and a foreign patent office. If these criteria, if any one of these criteria fulfills in your application, you may opt for the expedited way of the examinations. That means your applications will be examined early. Again, the detail about it is mentioned in our schedule. Okay. Now, here in the patent application processing, we'll see, you will see in this, you can see the flow chart, that we have a patent applications. Here we have the three routes. One is mentioned here, the PCT. About it, I was told you that if you want our applications be published or brand in multiple countries, so there is a one suitable route, that is called the Patent Cooperation Treaty, which is governed under the WIPO. It's a, you can say the office is situated in the Geneva. Then the convention applications. Then convention is a group of country, or it is again an intergovernmental organization, is a member of countries where we want to file conventional way. We want to specifically in a some of the country, and there is a ordinary applications. So this is whenever we patent application is there. So we have the three ways: PCT applications. We are going for the PCT filing. We are going for the convention application filing, or we are going for the ordinary applications. So here I'm telling you that if you are going for ordinary applications, whatever I told you earlier, you will see that first we will have the provisional applications. This will give us the 12 months of time. According to the section here mentioned is a section 9. You will have the 12 months of time to file your complete specification, or from the date of filing, we can go for the complete specification. When you have filed the complete specification, up to the expiry of the 18 months, your application will be published under the section 11A of the Indian Patent Act. After the expiry of 18 months, what will we do? Your applications will be public, will not be published. And I said here, from the ordinary application to the publications, there is a one, we can say the optional route is there, that is a route of the early publications. That could be finished in just, you can say the week, or just in a 15 days. if we go for the early publications under Form 9. This one is one thing. Then in case of the same way, in case if you are going in a conventional applications, you want to get it, so 12 months from the date of earliest priority, you'll have the 12 months of time, you can go for the complete specification. Here in the PCT, which will take a separate session on the PCT, that how the basic applications we reaches up to the PCT. This was a time limit of the 30 months of the time. Under the 30 of the 31 months of the time, your applications will getting into that stage of the complete specification. Then immediately published as is already published or not before 18 months. So again, there is a time limit for that. 18 months will be there. If it is already published, then it will will have the, you can say, the then and there stage for that. And our ordinary applications which is crossing that limit of, you can say, the 18 months of the time, it is reaching to the examination of it. So you will have the common platform for that. It's the examination of our applications. The examinations could be in an expedited way, as I said, by if it is a startup, if it's a small entity, or the government organization, if a female applicant along in a, you can say, the along with a natural person. So the examination of applications by examiners of patents, it could be for the designs, reports put to the controller of patents and designs. That is called, they will give us the first examination report. And this compliances, if this first examination report then hand over to the applicant, and you will have a 6 months of the time. And we can take it furthermore that we want to give the response to the, you can say, the examination report. If you are not ready with our exam, with our, you can say, the ready with our report within the 6 months, so there is again, we will take the extension of the 3 months. So there is an extension of the time by submitting a form, that is for the form 4, and here we have to pay some fee for that. So you were earlier asked me about that the form 4 is not mentioned. So this form is required if you want to take some extension of the time, will be here regarding the fee. We have to pay the fee. So the compliances by applicant within 6 months, we are giving up a response to that. If the examiners satisfied with our response, they will put our applications for the grant. Okay, so the examination of the amendment, and in between them, whatever the amendments or the changes is required from the, you can say, the examiners, they will fulfill those criteria. So the examination of the amendment will be further will be taken by the examiners of the patents or the designs, reports put up to the controller of the patent and the designs, issue of the subsequent examination report. And after the first, we'll have the subsequent examination report. If in between them some oppositions will be there, then we have to take the time for, you can say, the resolve those, you can say, the you can say whatever the opposition is there. This could be resolved in terms of the hearing, or in terms of, you can say, the disposal. It could be in a form of the rejection, or it could be in a form of the grant. So these are the steps which is required for the, you can say, the processing of an patent applications. Or then this is one step that is called the screening and the classifications. In a applications for patent filed by the applicant, then we go for the screening. And in the screening, we can say that if the invention is related to the atomic energy, as I earlier said, that our section 4, that is what is not patentable, we are going to the screening of it. So the inventions related to the atomic energy or inventions relating to the defense purposes, if some, okay, if it is for this coming under that, you can say, criteria, then your inventions be referred to the atomic energy department and your inventions be referred to the DRD. If the persons who are going to screening your application, they found that your inventions be related to the atomic energy, so they will refer to that. Otherwise, it will be going for the publication of applications. So from the references refer to the atomic energy departments, they refer your applications, and this will be referred under the Atomic Energy Act. And they found that it is not related to the atomic energy. And there the references from the DRDO. Therefore, that it is not related for the, you can say, the defense purpose. Your inventions is not coming in the criteria of these two sections. Then your application is ready for the publications. So that's why if we are not going for the expedited way, this time limit is for the 18 months. But if you go for the early publications, this would be completed in just, we can say, the 7 or 15 days. And after that, allotment of applications to the exam. So again, in a shorter way, I'm just telling you that this is the stage that it will be reached to the examiner, and the further procedures will be followed by the flowchart I have shown in the previous slides. So examination, formal examinations, it could be the technical examinations. We are getting the first examination report. So the gist of the objections are communicated to the applicant. Examinations on reply of applicant. Check reply, re-examine, remove the objections which met the requirements, communicate the pending, you can say, objections to the applicant. So the examinations or the reply of the applicant. This will be further checked. Then there will be, if some opposition is raised, so opposition is raised, or even if the examiner thinks that the hearing is required, so the technical discussions on the pending objections between the applicant and the hearing will be there. And if the opposition is there, so there will be the opponent also will be present over here in this hearing stages. And if these all will be resolved, then the grant or refusals order will be communicated to the applicant and informed of by the controller. So decision of grant or refusal to the refuse the patent based on the pending objections and submissions of the applicant. So these are the process. We will see all such things about this examination steps, how the reports are formed, what are the, we can say, the documents we submitted in form of the specifications, in terms of the communications to the controller. All this we will see in their sites. So in one of the sessions, we will see how to read, or we can say how to read the different parts of, you can say, that the stages of the applications, or stages of the examination of the applications in form of, in our particularly in, you can say, the sides of the Indian Patent Office. We'll take it in some separate section about it.
Yes.
So, right? Then the technical examinations, read and understand the inventions in relation with the drawing, search for related earlier publications on worldwide databases, check for novelty and inventive steps with respect to the citations, prepare detailed examination reports. So what could be the technical examination? So these points will be considered for preparing the examination report. So if we can further say that why the examiners, we can say why it's time taking. So the certain stages, the certain steps are required to check the novelty of our inventions. So that's why we say that these all things will be going expedited way, because there are the number of applications at the patent office. So it will take time to reaches into the, you can say, to give the examinations for each other, because the different sections are there. So we can go it for that. We want that the work will be done in a fast way. So the fast food is given in an expedited way. So we have to pay some extra fee for that. So this is again the time limit, which is again summarized here, that the provisional will have the 12 months, request for examination 48 months, reply to FER 6 months, or if in a with the filing of the form 1, if you are not, we can just submitting the form 3 or the form 5. So again, we will have the time that within 6 months from the date of filing of your applications, you can submit the form 3. But the form 5, that is for the declaration of the inventorship, you have to pay in just 1 month from the filing of your form 1. If you want to withdraw your applications, you can withdraw it within 15 months. You think that you will not be able to complete your complete specification, or you will not have the sufficient, you can say, the novelty in your inventions, you can withdraw your applications. Hearing submissions, you will have a time of the 15 days. Here again, we will take some, you can say, the adjournment of the hearings. This is again some the time extensions limit is mentioned. Pre-grant oppositions, before grant, anytime before grant, we can go for the pre-grant oppositions. And the post-grant oppositions, after the grant, will have the 1 year if you want to put some oppositions. So these are the some time limits which is required in order, you can say, the file it till grant process. As I was telling you that what are the benefits. So this was an example the donation of a patent. So here is the Padma Shri Honorable Professors Raj Gopalan Vasudevan. Here I am giving the patent number of this person. He patented the method of in 2006 and sold it to Indian government free of cost. This road is made from the waste plastics. So it's a method for making the plastic, the waste plastic for making the roads. He has donated to the government that people can use the benefit of their invention. So I was telling you the one of the, you can say the noble uh, prospects of our patented invention is in a form of donation. Okay. So about that, it is mentioned over here that here is a link I have mentioned here. We can check this link and whole about how he did his invention, how he is invented, and how he has that the patent invention he has given to the society about him is mentioned over here. Or we should run over here also. Okay.
Yes.
This one is that, right? So as I discussed, we have discussed in our we can say the previous lectures about the patent filing system. So today we'll take some interesting examples, and we'll take the example of our, we can say a very known or very, you can say the uh, uh, easily used in our daily, we can say the part of our kitchens, that is the turmeric. Can we think that the turmeric, as we are aware, it's having the wound healing properties, be a subject matter of a patent in its the powder form and all that? Even we can say the small kids, if we can say our family member, everybody is known about its, you can say the healing property. But there is a case study which I am telling to you that the use of turmeric in wound healing. So this was a patent which is, we can say, awarded to awarded by the United States. So a US patent on turmeric was awarded to the University of the Michigan Center in 1995, especially for the use of turmeric and wound healing. Being an Indian citizen, we are aware that this should not be patented because it is a well-known thing, it is in our traditional knowledge. So this patent also granted them the exclusive right to sell and distribute the turmeric. So on 28th December 1993, the US-based Indian citizen, that is Suman K. Das, along with the Harihar, filed a case entitled The Use of Turmeric in Wound Healing, depicting method of promoting healing of a wound by turmeric to a patient affiliated with the wound. So this was a one patent. This the US that we can say the US patent office is awarding to, you can say, for in their country. But we know that we can claim that is in our, we can say in our one of the sections where the things are not patentable. It is mentioned that a method of promoting healing of a wound in a patient which consists essentially of administering a wound healing agent consisting of an effective amount of turmeric powder to set patent. So we know that this is in our traditional knowledge. So it should not be a subject matter of patent. We all know about the healing properties of the haldi. So from our traditional knowledge, we can say it is not fulfilling the tradition. We can say the fulfilling the criteria of the patentability. So under this clause, we can say is mentioned in our section 3P, which indicates the inventions are not patentable, under which it says the invention which is in fact is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. This should not be patentable. So definitely we should oppose it. We have filed, we can say, the opposition against, and finally the patent was revoked. And we get the judgment in our favor that we can say that some countries the traditional knowledge will not be a patented. Along with that, with certain examples, not only the haldi, we can say we have some formulations of the jamun based. We have the bitter gourd, we say the gudmar, and we can say an eggplant for the treatment in diabetes. So the composition of methi as a tonic to bring down blood glucose levels. So there are so many, we can say this formulations is available in our traditional knowledge, which we are aware, with which we can say our the ancestors are aware with it. So this should not be the part of patent. Along with that, based on that, we can say the traditional knowledge, our, we can say the Council of Scientific and Industrial Research, they have prepared a database which is a valuable assets, which consists of, we can say, of 1200 Ayurvedic, Unani, and the Siddha formulas, which is a compilation of this one. And this TKDL, you can say the database is given to the WIPO also. So the contribution of the, our, you can say the CSIR of the laboratories. And this one, along with the Ministry of the Ayurveda, Yoga, and Naturopathy, Unani, Siddha, and Homeopathy. We can say the Ayush Mantralaya. This database is there, which is a prior art database of the traditional knowledge globally to prevent the exploitation, to protect the traditional knowledge at patent offices worldwide. So this database is with them. An effective deterrent against biopiracy, a model for protection of traditional knowledge, a valuable yet vulnerable asset to indigenous and local communities, sources of their livelihood. So this database is prepared, which is compiled, we can say the 1200 of our, we can say the medicinal formulations, which we can say should not be a subject matter of the patent. And here we'll have, we can say the sum of, in this, we can explore this traditional, we can say the TKDL library. And here we'll get all about, we can say, all, we can say the herbal plants, medicinal plants, and all that information is gathered over here. And their platform is that a valuable resource for the patent examiners. Though we'll examine the such type of, we can say the traditional knowledge based, we can say the patents, somebody is unaware. They're not aware with our traditional knowledge. So that's why this database is provided to them, to the examiners in international patent offices. Here it could be in the English, German, and the French, Japanese, and the Spanish languages to prevent the granting of erroneous patents. So this is a valuable, we can say the database to prevent, you can say the biopiracy of our traditional knowledge. If something related to our traditional knowledge is going to, if somebody is going to file a patent for that, so this valuable assets be used by the examiners to give the, to check the patentability criteria of that application. Now let us one interesting example. In our previous session, I was telling you that what could be the benefit of filing a patent. So there was a one interesting example is in a form of a patent can be donated. So here is with us the Raja Gopalan Vasudevan. Prior profession, he was he was, we can say, a professor of chemistry. He is from the South India. Recently, he is awarded the Padma Shri, and he is called the Plastic Man of India because in, we can say, the 2006, as during his research, he found that can we utilize the plastic waste, the different kinds of the plastic waste. So he has utilized one, we are aware with the recycling of it, but the recycling process creates so many, we can say, the waste and the toxic fumes, flue gases, which is, you can say, the harmful for our environment. So he has utilized his creativity. Why don't we convert into making the roads? So this was the noble cause of this man, is that the tremendous amount, we can say the tons of the waste materials, the plastic waste materials, he has tried to convert it in to making the roads. So initially for the experiment purpose, he did these things in the campus of their, you can say, the college. When he found the, you can say, the relevant or the reliable properties that he was assuming, when he satisfied that this could be used for making all, we can say, our roads, so he filed a patent in the 2006. The patent number for this he was granted, and for the, you can say, the, he was aware with the utility of this, you can say, the concept. He has shared, he has given his invention to the government of India, and we can say at present more than 11 states are using their concept, this their patentable inventions for making the roads in our most of the states. So this one is, we can say, that the Professor Rajagopalan Vasudevan, we have this type of examples with her, that if you will search the Plastic Man of India, so you will get the all, you can say, the detailed information of how he did his research, how many people are associated with him. You will get it about that. So this is one in a form of donation of a patent for, you can say, the noble cause. The second, we can say about the Thomas Edison. The value of an idea lies in using of it. This was the thought of this person. So Edison General Electric, this was it inwards in the 1819. Today's we call the General Electric. We can say about this one that This is having, the person is having, that is a AJ Kumar, that the consulting engineer is having more than 300 patents in its, you can see the credit. So again, there is a link. If you get time, you will explore it and you will find about that how many, you can say, the mechanical part, the electrical part he has used to file a patent. So this is again one, the single person, that is the General Electric, is having the more than 300 patents in their credit. Another one, can we think that the king of pop, that is a Michael Jackson, is having a patent, is having a US patent? It is called a patent. The Michael Jackson, the king of pop, patent a special shoe. We could say the anti-gravity illusion or anti-gravity shoes. We'll know that whenever he go for the, you can say, the stage performance, he has having that to tilt his body to a very, we can say, the near about, because of the less than 40 degree angle, he can bend his body. So what was that? It's a, we can say, a particular type of shoe that was designed by this person, that is called the anti-gravity illusion. So this is one thing, that the patent is granted for the celebrity, like the, we can say, a celebrity patent. So this is again, we can say, the invention we have in this way. This was, you can say, that the how the shoe was designed. This is all is mentioned in its that the patent, that is again a US patent. Next one, in the same way concept, the leather gripping attachment for shoes. So this was in 1913. This again, we can say the anti-gravity, you can say that the gripping device, gripping device were attached the shoes to balance these persons. So we have this type of, we can say, the examples that was in 1913 was filed for Edmund Dennis and leather gripping attachment for shoes. So this was a patent in April 15, 1990 or 1903. Another one, it's an interesting patent. We are familiar with that the laser lights. Can we think a laser lights be a playing device? Will be granted a patent that for a playing device for the kids. So this seems very funny, na? That laser device we are using. You can say the pet, you can say the toys for that. So a method of exercising a kid. You can see the name of that, a method of exercising a kid. It's a patent for use of a laser pointer as a cat toy. So can anyone imagine to use a presentation pointer? It's just a pointer for us. But you can say that use is for, because we can know in most of the, you can say that in US countries, they are the pet lovers. Then every home they have a pet. So how they will play? So they make it, it's like that in a form of a shape, which provides a light, and in the direction of the light, the cat try to play. So this is again, and it was, you can say, the highly demanding. The cat toy marketed at a pet supply stores, and there was sometimes like the, whenever they go for the visit, they say that this device is not available. So this was the situation where some, you can say, a simple thing can be used for a device, but such simple things will not be, because we are aware with the utility of it in a form of just a pointer device. Such thing of is not patentable in our country. Another interesting, a pet umbrella and lash. It is again a simple creativity. It's a band along with a, you can say, the umbrella. So this was again a patent in the 2005. So it's, we can say, the utility of it, that a dual purpose. Along with the umbrella, it is a lash also. So this was again a patent granted in 2005. Next, this is again a very simple thing. That is a British boy. That's called the Sam Horton. He was sitting that in a park, and he was seeing that his father was using that this broom for the cleaning purpose, the cleaning room. And he used to say that his father taking so much, it takes too much time, and he's using a single, you can say, the broom. So we can say, can we add the double broom into a single handle, which could be a time saving also, and the less efforts will be that the father will have to do less work. So this is again the creativity of, you can say, when this boy was just 5 years old. So this was in a simple thing that we were thinking that the smart persons or the educated persons be the part of it. This is not the case. So this was a simple boys a creativity, that the thought came in mind, and presently we can see in most of the roads that the person's using the double broomed, you can say the double uh, that uh, headed double headed brooms for, you can say, the cleanings. Next one, there's a one thing that is a gifted, we call it the gifted kids, the youngest patent holder. It is said that the Hridayeshwar Singh Bhati is an Indian student who invented a six-player variant of chess. He invented the variant at the age of 9 with his father's assistance. He was granted a patent for his invention in 2012, making him the youngest patent holder in India at that time. So this was again the creativity. You will again, you can say that this uh, uh, that more detail about that how he has prepared this. You can say the six uh, uh, player variant of this. You can say the chess. So this again good example about that how we can go for the patent of the uh, child's creativity. Another one. This is again the youngest patent holder CEO India. That's called the Library has given made this girl the CEO of their brand, that is called the for hand you can say the wash. So this is Vaishalini NC. Vishalini NC at the age of 7, she was invented an automatic multifunctional lice rescue flood house which can prevent drowning during flood disasters. She is one of the youngest patent holder of India at the age of 6 years, and she is a recipient of the Pradhan Mantri Rashtriya Bal Puraskar Award. And now, with this, that the Lifebuoy we can say has given that that the brand ambassador for the H stands for, you can say, the hand washing. After the Corona crisis, the Lifebuoy has hired this as a CEO, the youngest CEO of that company for the hand washing. So this girl is also, we can say, an awardee of a patent. Another interesting example that this a 14-year-old girl, which is the Ramya Josh. She has invented a pedal powder washing machine from the bike parts. Nobody can afford that. You can say that the expensive washing machines, the variants of it. So she has just used the pedal, cycle pedal, and converted her devices to make a washing machine. So this again we have the very simple creativity with us, and we know the how the value of these small you can say the that creativity of that of their mind, which is quite useful in our daily life. These are, I must say here, mention here that in the recent last 2 3 years, the Chandigarh University makes. We'll see that nobody is filing the patents. Why we are not aware with that the patent filing facilities. But here is an example that the Chandigarh University makes national record in the field of research, has filed 500 patents in 7 years. So this is all about that. You will see that the students of that university, they are actively involved in the research fields, and they are aware with the patent filing systems and making a record or filing so many patents applications. So we have this various examples that we should uh, get the knowledge about it. We should get time to time to collect the informations from these, you can say, the sites which are giving us many, we can say, that the ways or the channels they are providing. Some, you can say, the scholarships they are providing, they are motivating us, they are promoting us that we should go for filing of our patent applications, we should go for the protection of our creativity instead of generalizing. So this is another example. Rest about that is available, how to get some information, general information, your queries in our WIPO, and that is in ipindia.gov.insights. This is, we can say, our websites. That is the front page of it. Here we can say that you will see in this tab that the patent, designs, trademarks, geographical indications, and this is RGNIIPM, Rajiv Gandhi National Institute of Intellectual Property Management. This time to time conduct the various short-term courses of 1 day, or we can say the 3 days, 5 days, weekly courses to the students, to the organizations. They nominal fees they charge, and they provide them that in any of, you can say, the field of IPR, whether the patents, you will get the information of the patent filing. You want to get the information of the trademark, you can get it how to write a good you can say the complete specifications. So all in the streams they provide the, you can say, the short term courses. Along with that, if you'll explore these, you can say, the tabs, we'll get the valuable information about it. While we were talking about how to file a patent application, so there I said that patent is not a worldwide application. We have to file, it's a territorial right. So being a citizen of India, if you are going to file a patent application, so the Ministry of Commerce and Industry, Department of Industrial Property and Promotion, DIIPP, then our CGPTDM, that is called the Controller General of Patent Designs and the Trademark. Here we'll have the various patent offices. Okay, so in the patent office, we can say we have head office of the patent is in the Kolkata. That's the branches in, we can say, in Delhi, in Chennai, or we can say in Mumbai. We have the Mumbai patent office, we have the Chennai patent office, we'll have the, we can say, the patent office in Delhi, we'll have the patent office of the Kolkata. So Kolkata is a head office where Chennai, Delhi, Chennai are, you can say, the another offices for that. I just told you about that, the RG and IAPPM. Along with that, the trademark registry head office is in the Mumbai, geographical indications is in the Chennai, and the copyright registry is in the Delhi. Along with that, the semiconductor layout designs, it's a registry office in the Delhi. So these are the offices we have to approach for filing our patent applications according to the jurisdiction. So these are the, you can say, the Delhi, Mumbai, Chennai, and the Kolkata patent office. And here we can see the jurisdiction for it. Like for the northern states, we are from the northern states. So where do we file the patent applications? Our jurisdictions will be towards the Delhi. If we are in the southern states, our patent office, we should approach to the Chennai patent office. I'm from the Madhya Pradesh. So my jurisdiction will be the Mumbai. So the western regions is coming under the Mumbai. The rest of the India will be the file their application in the Kolkata. Foreign entities depends on the services. Accordingly, they will be. So most of the, you can see, the foreign entities, we can see the PCT applications, they will be handled by under the Delhi Patent Office. So this is about the jurisdictions. We are ready with the information, but where we to file, we have to decide that this particular patent office we have to select. So that's are the examples related to that, about some examples. And if you have some doubts, you can contact me that you have some that where to file, how
We
to
can
prepare
also
that.
we can also make a live session at the end after all the session. We can make a live session so that if they have questions, they can also post on that comment box also. We can definitely we can answer of their questions. And but these are all the basic things we discuss about these things. But now important though we have understand the several like ideas like that those who have patented already we understand from your several lectures that what is a patent and how one can patent the files and how the small things also the small innovations also can be patented. All these things you explained very nicely. But now the question is that like as we know that so many patents are available, but if we want to search a patent, then how we can search that patent? So that is important to understand, like the important to understand how we can find a patent. So if we can for those who are researchers, like they are searching some papers, if they are interested papers to paper in Google, if they write the papers, then it is difficult to get it. That they have to write some the title and then so many. But the easier way that Google Scholar, like if they will go to Google Scholar and they can find the paper just by typing the title or by the name of the authors, they can find it. So similarly, there are any process to find out that about these patents? Similarly, any sites are there? Sites are there. All these things.
Yes, definitely. We
Yes.
have the,
So,
we can say
so
that.
in our next session, we will understand that what are the sites available for a layman to search the patent. So I think in a hand-on experience, if you can show us that how one layman can search the patent, and so that they can able to get the patents easily, so that will be very helpful for all the researchers, so that different types of patents, how they can search it.
As we have seen about the importance of patents, that we should file a patent. But the question arises how to search. Can you tell me, Dr. Arpan, that how we search our research article? What is the easiest way? Suppose for a layman to tell you how to search a research paper, and
Yes.
what are the various routes for
Yes.
searching?
Yes, usually if a new researchers start that when someone comes the new, they want to start the research, then usually like we suggest that go for Google Scholar, and in the Google Scholar just type the title of that of your research area, and then in that Google Scholar, to in the Google Scholar, just if they type, then they can get several papers on that Google Scholar, and then they can there they can download the papers from Google Scholar. They're using like Google Scholar.
Exactly. As you said that for the research articles, easiest way for a layman is a Google Scholar.
Yes.
Similarly, let's see.
So for patent also similarly different sites are available.
Yes, we have the, we can say the simple,
Okay.
various sites are available, and
Okay.
as per the need, that easiest way, the
Like
basic
in
search. First, we go for a basic search.
okay
As we are not
in
aware with the
and also
complex
in
search, will not go. We go for the
okay.
basic search.
Okay.
Okay.
And also when like a researcher, like the from the first beginning that they start with a Google Scholar, and but if like after that we usually suggest that if like they want to particular on that area, that they want to like search more like some that high impact journals or that, then particularly we want to go to particular sites for more specifications or particular publishers. We want to go to the particular, we want to suggest that go to particular publishers, and then there you can download all the papers. Particular publisher, like you can say like the, because the important to know the all the research about that particular field. So then we suggest them to particular like some Nature or some very good journal, very good publishers we suggest, so that they can go there and they can search the articles, and they can get also from that specific publishers, they can also get several articles.
Exactly the same thing that in our research we go for the literature search, and as per the need we go for a specific journal and a specific site. As per the
Yes.
requirement, the same concept we will follow here. So today
Okay.
we'll start with the basic search. Just in a Google Scholar, we search the research papers. Here we go for the Google patents. So first we
Okay.
go for a type Google.
So I think you can share your screen so that
Okay, my screen is not visible.
yes, now it is visible. So
It
what
is
is the
visible now.
site for, yes, what is the site for this?
Simply first we go for the
Google Pay.
Google
Okay.
web page, and we'll
Okay.
type the Google patents. We are
Okay.
just
So
typing the
from the
Google
in the
patents.
Google itself, we have to type Google patents. Yes.
Yes, we call it the
Okay.
Google patent. It is the easiest way for
Okay.
the simple search. First we go for the Google patents.
Okay.
So when we go for this Google patents, here
Yes. Okay. We have to.
the
Oh.
Google patent,
Okay.
the
Okay. Like
logo we are
Google
getting of the
Scholar.
Google patent.
Yeah. Like
Right.
Google Scholars is for research papers. Similarly, Google Patents for patents.
Is
So
for the patents.
okay. So really, it will be very helpful for all the researchers. I think those, because they don't, if they don't know about this thing, though they have some novelty of their work or innovations, they have importance, but if they do not know that where they will get the patents, how they can search that about that area, whether previously patented or cited a patent, already patented of that work or
Definitely.
not. for them this will be very helpful. Okay, so then for a layman purpose, they can go directly with Google Patents. Yes.
Then one thing is that by this search, we are getting that how much research is already done, the thing which is our in our mind. So this is a
Okay.
prior art for the search. The easiest way, if you go for the Google patents, we'll find out the, you can say, the number of patents relevant to our invention. If we get some, we can say we can get some, you can say the relevant or the similar kind of inventions. So we'll have that the such thing is already present over there. Then we try to modify our inventions and we try to add some all new elements into it. So this is a basic, we call it the prior art. So first,
Okay.
we
So
just
I
type
think
the
you
Google
can,
patent.
yes, I think you can like some examples if you can see,
Yes.
then it will be very helpful.
What
So
do I type here?
yes, I think we are discussing like that today. We discuss some plastic that in our
Okay.
previous lectures we discuss
Huh.
some plastics.
So
So
I just go for the plastics. How many? First, we go for the broad search. Then we can go for the narrowing of it. So I'm just going for the plastics. Suppose I'm going for the plastics. Is there any plastic, or we can say the plastic materials? Okay. I
okay,
just typed over here and just then see. So here you can see when we type of such a word, we are getting more than, you can say, how many 1 lakh results is shown over here. So this is
okay,
one thing, the plastic materials. And you will see that the first one I'm getting the use of phosphorus containing organic oxamides as a flame retardants and in this the plastic materials, so many, we can say the search patents are displayed over here. We can narrow down it. We just go for this, you can say the pen icon, right? At the
okay,
top of it.
okay,
Let's go over there. And here we can go for the specific search that
okay,
here is a plastic material. This is our search. Then the date and the priority. We can go for the from, suppose we just go for the last 5 years and just go for the last 1 years. What are the patents published, or we can say the granted applications are there. So we can select here that we specifically want the 2020 to 2023. So we can
okay,
narrow over, you can say the search in this way. Suppose I'm writing here 1 20 01/01/20 till today. So I will write here 2904/2023. Till that date, we want to see how many plastic materials based applications has been filed. Okay,
okay.
so we will just want to go for that. So this is one thing. Then there could be, as we are not aware with the inventors, we are not
Yes.
aware with
Now
the,
I
you can
think
say the
came
assign,
here 1 lakh something.
something is there.
Yes.
Then
So
here is that again there is a some, you can say the points that a patent office, so we can specifically search from which patent office we want the patents. So this is wo, that is the world, that is, you can say the WIPO sites, how many applications were there. And we just want from, you can say that US. If I'm selecting over here the US, so all the, you can say the patents will be displayed of the US country. So this is
okay,
one,
so
we can say the
means
refinement of it.
means I can like means when first in the Google patent we will
Hmm.
search the patent, then it will show the patents, number of patents that will be from all countries. Like we, that is
All
not
countries.
okay. That is not that for particular any particular country there will be not, they are not displaying any particular country. For all
Right.
country it will come.
Mixed, we can see the mixed list of the patents relevant to our title. We
Okay,
are getting over displayed over there. But
okay,
our
so
intention is that I am the US citizen of India,
okay,
US citizen. Then my intention is to file a patent in the US country.
okay,
So I want to search that how many similar kind of patents has been filed in my country.
okay.
So that's why I'm selecting over this one.
Okay. So if
Okay.
we, for particular country, then we have to here we have to come in the pen and then here you have to select that country name. Then
Hmm.
on that country, how many patents are available? Then we'll get particular for on that country for that country.
Right. And
Okay.
just a side tab, there is a language option. So here
Yes.
in this language options, many languages are there. They
Okay.
will be in there, you can say the German, Chinese, French. So instead of, so they will give us the provide us a translated version of it if you go for
Oh,
the English. So I'm going to select here the English.
Okay.
So the patent, even of the country, even if the Chinese country, will be displayed in the English version. The translated form of that will
Okay.
be displayed over here. Okay.
Okay.
So just we have typed here the plastic materials, and yeah, here we have displayed here so many things. If you
Yes.
further want some refinement, if you go for the plastic materials in making, plastic materials in making
For
as a
road, I think road we
road
are.
what?
I think you
So
given the
we can
example.
go for the plastic materials in road making
Yes.
and road. So we can go for the plastic and road. So we'll see that how much we are going to get the displayed over here. Another thing, here in this you can see the tab, the sort by. Here we have the certain, you can say the headings. First is the relevance. Under this top down, we are getting the relevance is the newest or the oldest. So we can
Okay.
select here the newest one.
Okay.
So you will see that the number is decreased to now in the thousands.
Yes.
So this is called the filter. As per
Okay.
the requirement, we can apply the filter over here. Okay. So we'll just go for the newest because we are to file some new invention. So as per our need, I have selected that I want the recently in the past 2 years, which we have already selected over in this, you can say the date option, date tab. Similarly, we can go for here in the relevance, we have the options like the oldest or newest. So I have selected the newest. And if you go for the oldest, you will see the number is 17,129. And if I go for the newest, the number is 16,537. Because earlier we are getting a more than 1 lakh because we have not, we can say that a confined our research to years, but here we have confined our research to the years, that whatever is going on between 20 to 23. So as per our requirement, we can select the how many last 5 years, 10 years, whatever the, you can say the years patents we want to search. Second thing is group by. So group by none, or here is a group by the classification and none. So here just we are going the way it is uploaded here. We are not applying any classification and nothing. We just go for the none. So we selected like this. Then duplicated by, because there is another topic which is a topic of discussions, we'll take it later, that we have to design the patent family. The something, the patents, as I say, we can file in multiple countries, so that becomes a family. The same patent in the USA, the same patent we have filed in the China, so it becomes a family. So instead of that, duplicated by family or by publication. So whatever the way, we can go for just by the publication. So if you are going for the publications, you will see the number is more. But if you go for family, you will see the duplicate number will not be displayed over.
So what is the difference between family and publication?
Family, and that means we say the same one patent we have filed in India, but we know that the scope of our patent is some other country.
Okay.
And in some other country filing, we can say we can approach, we can file to particularly that country. Otherwise, in my previous I said that there is a PCT route.
Yes.
We can file in the multiple countries.
Yes.
So when the same inventions we are filing in multiple countries, so that family will become a, that patent will become a family. So
Okay.
the same patent is in a number of countries. So the number will be, if we are going for the individual search, it will be an individual patent. But we are selecting here the family, so that the duplicate number will not be displayed over. So you will see that if we are going for the no family, we are just going for the publication. So the number is what?
Yes.
19,000. But if you are going for the family, that means the same patent is filed in the two countries will not be displayed over. We'll
Yes.
get it together. Okay. So that's why here the number is reduced. And the second next option is a quite simple one, that how many you can say the results you want in a per page, but 50, 20, and that's it. So
Yes.
this tab is also important when we are going for our search in a general search, because once we see that the 1,000 numbers, or we can say the 1 lakh numbers is displayed over here, so we get little confused that how to select the one which is relevant for us. So we have to apply certain filters over. As we say the plastic material, so we are getting, oh, 16,000. Is it possible for a person to read a 16,000 patents? So we have to, again, we'll specify the area where we want the application of these plastic materials.
Yes.
Okay. So accordingly, I am citing plastic materials in
Road making.
road making. Let's see what are the results we are getting.
Yes.
You will see here we have 15,448 results.
Yes. So this
Right?
is for all countries, right? Or
This is for, as we have not selected here, so we are getting for all countries.
all countries.
Here I have not using any filter.
Yes.
That you will see that all these parts are, so that's why we are getting here.
Yes.
Just for example, I am writing here just for, you can say, the last 2 months, only for the last 2 months. So I will write here, suppose 01 02 2023, okay, till today, that is 29/04/2023, okay. And patent office, again, we are not selecting this one. We just want that the worldwide, how many applications are there regarding this one. And will we specify, we are not even going for the language also. Okay, we just go for this one. Then we'll see that how many results we displayed. So something, just a minute. I have used a different format. Here is the first is a 2023. It's a year.
Yes.
Then 0, 2, then 0, 1. This is a format, year, month, and day.
Yes.
So again, I am writing here 2, 3, 0, 4, 2, 9. Let's see what results will be displayed. You will see that the number is just a 430. Okay, so the plastic materials road making, before here, that the priority is mentioned. We are getting 430 results. Here we can specify again now that we want just of US country. So there is no patent filing. You will get it.
Yes.
If you go for the EP,
yes,
no results.
EP means?
Okay. EP means the European country.
Okay.
European Patent Office.
Okay.
European Patent Office. Okay. So that's why I'm
India?
just going for the.
Can I go for India also?
You will get it.
Two. Yes.
Two patent.
Yes.
Okay. So the patent is there, but they have got gone through, you can say, the WIPO sites. That is the PCT weight. Wherever we get the WO in the number, that indicates that is that patent application is filed through the PCT routes. Okay. So this is one thing. So you will see that a basic search can be done.
Now I think it is very clear that how a layman can search the patents. Like if from Google patent, they will in Google they will search Google patent, and there they can search the patent title. Then they can able to get all the patents, available patents, and then that they can filter in different ways. Like if for different countries, if they want, particularly for India or particularly for US, that also they can segregate from that from there by using these options in the by making the pen mark. They like year, that from where to where they want, they're interested, and they can put there. And then the country also they can select that from that which country particularly they are interested to see the patent file. Then they can also put the also the country name also they can put, and also family, and also in the upper we saw the several options that also they can play to get the number of patents by filtering in a various way. So really it will be very helpful for to them how they can search the patents. So any other options also there to search the patents?
Yes, there are many options, but here in this again we can go for a one step ahead. That we click onto this into that one.
Okay, that will
it will
yes.
be displayed.
Now we will now like we will just focus only on that how we can search the patents, and then later we can also understand about that that if we can go for specific patents, then how one can read that patent, and how they can, like, whether it is filed that. Yes, one more thing, the question that those patents we saw there on the previous on the previous part, that the
Example,
patent,
yes.
Yes. So those are all are like filed or granted or mixed up. Like when
Yes.
we search in that patent, then the whatever the results comes, like they are all are like all are mixed up will come, or no, only granted patent only we can able to see there.
When we have the number of that patent, then we get the specific that patent.
Okay, so
That is
means
a different way.
only filed patent also we can able to see there. Like when we search,
Yes.
means
Yes,
not
we can.
granted, but we can see also that one also.
Yes, definitely. If we have that
Okay.
number, we can go for it. So this
Okay.
is
So
again a
then
different route.
So then also that is very important in the later stage. We have to understand that how we can understand by looking a patent whether it is granted or it is only filed. So that is also I
Yes.
think important to know that whether a patent is granted or not. Or in patent, I think some file number also we can able to see for all patent they're giving some file
Yes,
number.
definitely.
So
Some numbers is there.
also in that number, each digit have some certain role.
Yes, definitely.
Okay, so
There is a,
that
you can
also
say, the
then that
code.
will be also very interesting. So that also we have to also understand that in that patent number also what each digit suggests. So that is also very important to know this. So I think like in our next upcoming sessions we will understand like that in a when we will like today we understand that how we can search a patent, but after that I think if you can clear us in our next videos, if you can clear us that that whether how we can understand whether the patent is filed or the patent is granted, that one will be very helpful for everyone. And also the next also if you can like the coding, that what we can understand from that. And again I think some like whether this is PCT file or this is only for a particularly one country or PCT file, so that all these things you will clear, it will be very helpful.
Yes.
So now you can summarize that what are or any different routes to search the patents. Any anything, any specialization also there, like in our research article when we will go for like in Google Scholar we are going, and after that also we can go for a particular specific publisher sites. Like suppose as I can say, suppose that we will search a particular field, then suppose we want to see that whether these publications in nature like Springer Nature, so we will go to the nature journals, and then nature publishers, and then there we just search how many like in specific particular specific nature, or LCV or Science Direct or any other particular publishers we can go, and there we are searching. So similarly here also say options are there or no?
Yes, there is option. For example,
Okay.
we want to search some Indian patent. So where
Yes.
should we go?
Oh, there is also for only like here as you show us that there if you can put the country name and we can able to see that pattern, that is will be not enough.
It's a broad, you can say a broad way of searching some, you can say the your invention. But specifically, we
Okay.
just are interested only in the Indian patents.
Oh, then
So
there
we
is a
should go for
different
the
route.
Indian side.
Oh,
Different route.
okay. Then it is then very interesting. Okay, so then in our next video, then we definitely first of all we have to understand that how we can search some India patent in only for India patent, and for only for US patent. Then also here also we can go to
Right.
specific for searching.
Countryside
Okay,
in a
okay,
specific
okay.
country.
Oh, then it is completely similar, like the research article also it is completely similar to that. But
Yes,
routes are
definitely.
really different, which is
Right.
not known to everyone. So really, it will be
Yes.
really, it is important to know every researchers regarding this. Thank you very much for your time and for explaining us in detail that how a layman can search the patents and how they can segregate the patents. So and then our next lecture, so what you will clear to everyone.
We'll go for the Indian patent side, that how to search the Indian patents. And here I put one, you can say the exercise. Yes,
Okay.
in our previous, you can say the talk, we are talking about that the Padma Shri Rajagopal and Vasudevan. He was
Yes.
a plastic man of India. So, as the name is well known, so here in the search options, there was a name, the name of the inventor. So, by just putting that the name of that person, we can also search the patent of that person. We can see the plastic material for making the road, and along with we are mention the name of that inventor. So, our search will be little bit easier. That we are going towards the easier side, a specific person for that. So this is up to us that how we are. In my previous, we can say the slides or the presentations, I have mentioned so many, you can say the numbers, some patent numbers. So are we able to get the definitely the whole, you can say that the patent specification by with this number? So we can search by these numbers also, and specifically we are from the, you can say the search for the Indian patents, we can go for a specific site for that, and we go and put our, you can say the keywords, our titles, our, you can say the what are the relevant fields over there. We can go for published patent, we can go for the granted patent. So specifically we'll discuss over you can say the country wise the searches,
Okay, the
search
country wise
sites is
also
different.
different sites are also there. Like for India,
Yes,
you told also similarly also for US, and for
hmm,
Europe and also similarly also different sites are available.
right.
Okay, so then we can go for that. In like really it will be very helpful for everyone to like in a specific way how they can search for different countryside if they are interested for India. Then then what is the sites and how they can search. So that will be like this is for in a general way like whoever first they are interested to know. This is the easiest way they can search. So
First we go for the easiest way, and
yes,
second thing, though is having some invention and some person is approaching to you that they want to file a patent. So the first step is what? So search the previous patents. So it's the most
yes,
important thing that you must know, that the searching is the, you can say the prime most important.
right,
So we should go for that. Okay. So
right,
the various routes are there. But we will first go for the, you can say the routes which is easily available to us. First we you should think practicing on those routes, then we'll go for the specific one. Then we go for, you can say the simple search, then we can say the moderate search, then we go for the, you can say the advanced search. So this is way you can say the searching is based. It's not so easy, but first easily we are just going for the title of it. Then we specifically go for the strategies is to be made to specific patent search. That means we require this, and so first it's a basic thing that we should go for the search
how we
of a
can
patent,
search a
how to search
patent.
it.
Yes, really it will be
Yes.
very helpful because many researchers they do not know, they should aware about that how they can search. Because though they have some innovations, but they should first know that whether the patents are available or not on that particular innovation. Though we are saying that it is my innovation, maybe not no results still yet published on that particular area, but they should know that first of all that they should know that by searching they should know whether any patents are there or not. So that is important.
Yes, it's a very important. It's a very important, and you can say the first step. If you are going to file a patent and some invention in your mind, then whenever the invention, even in your mind, you should go for the patent search. That
Yes,
we call it the prior art. Okay, prior art search, or we can say the patentability search. Based on that, your invention will decide it that it should be patentable or not. So we simply call it the patentable invention. So patentability search. Previous lecture, we have seen about how to search just a layman search of a patents. So we search in a Google. Now specifically a country oriented, we go for, should we go for India patent? How to search an India patent? I think it will be a good that basically most of the, we can say we are promoting the research or the promoting the patent filing practice in India. So we should know about how to search a Indian patent. Okay, right? So
yes,
here first for this is our, we can say the Google page for searching the Indian patent. First we go to our IP India site. So I am here typing IP India. My screen is visible, na?
Yes, yes. So
Yes.
IP
So
India means Indian Patent India or what?
Indian Patent Office is there. We can say the
Okay, so this
site.
is
So
the
I'm just
particular.
going for the
So this is the
particular
particular
site.
site for Indian patent.
Yes. Here I will go
Okay,
for this one. This is
okay,
the official website.
okay. Official
Official
website
website
for.
of Intellectual Property India. That is, we call it the IP India. In a
Okay,
abbreviated form, we call it the IP India, right? And this is the official website. We'll click in this site and we get this page. Okay, this is IP India site front page. In this site, we'll get all the information about what is going on in our IP India patent filing process, trademark filing process. But here we are going for the search of an Indian patent. For that, here we have, here in you can see in the small black window, there are the three options: comprehensive e-filing, then there is a public search, then there is a direct utility. In between,
yes,
beneath there is a e-gateway, and there is a, you can see the blue symbol. So we will click over that and we get the e-gateway. And here in this window, we are getting the public search. Here in this public search option, we are going to search for a patent, Indian patent. So we'll click into this patent option. Okay.
oh,
So I'm going to click over here. One thing. I'm going back again. We are reaching into that page. Instead of this e-gateway, we can also click into the public search.
yes.
We are going to get the
So if you click on this public search, then also will directly
we'll
go.
again we'll directly reach to that site. Okay.
Okay, so either we can go this way or also we can go this.
Or this way.
Okay, okay. So they all are included in e-gateway. So various type of things are included.
Things
But
are
among them,
included.
we will only search for the public search.
For public search. So we are
Yes.
reaching into the same window.
Yes.
Okay. Here into the
So we
public
just
search,
in Google, we just we just one have to type IP India
India
Intellectual Property India. Then that
property,
is the website for this Indian Patent Office, right?
Indian Patent Office,
This
official
is the
website.
official website. So
Website.
official website is Intellectual Property India, and then on
Right.
inside that we should do that public search if we want to search
Public
it.
search. And
And
in the public search, we go for the patent search.
okay,
Okay. This is
yes,
a one way, right?
yes,
We can click over here and just this beneath you will see that there's another tab that is called the status.
yes,
And here again in this status, we have the option like the patent.
patents, yes,
Okay. So if we have already filed some of our applications in the Indian Patent Office, so we can check the status of our application through this option, or
okay.
in the public search, we will click over the patent. So I'm clicking over here. So when
Okay,
I
so
click
we
over
can
here,
search here also the patent, and also if someone have already filed some numbers, and then also they can understand the status also by using this website, right?
state right.
So
It is okay. That is one thing. It is
okay,
easier for those one who have already filed the application. So they have an application number. So their
yes,
search will be specific search.
okay,
They just put their application number into that, you can see the window, and they will get the information how much their application get progressed. This is a
okay,
one way. So when we click into the patent, you can see the option. This is that new window will be open like this one. This is called the INPASS. That is Indian Patent Advanced Search System.
okay.
Okay. So this is
IP
the site.
IN pass in pass.
INPASS, that is Indian Patent Advanced Search System.
Okay,
This is, you can see the page where all the search will be carried out.
yes,
Right?
yes,
This is the site, this is the page, and we can, if we have this, you can say we'll save in our, you can say the tab, this is the IP India, IP India services.gov public search option. We are getting into that one. Even if we general Google it in pass, so we'll directly reach up to this page also.
okay.
But I have told you through our
Proper
official
channel.
website,
So proper, yes. So
proper
proper,
channel, we can
yes,
reach into. When
yes.
you will be habitual or of searching the patent, then you directly move to this site. But officially,
Okay,
how to reach, I am telling you the proper way.
yes,
Now, here we have in the tab, you can say patent search, patent e-register, application status, and the help. These are the four options. Here in
yes,
the patent, this is a patent search. So in the patent search, there you can see the number of options are mentioned. What are that? The select search field. What you want to do? Application date. Select a search field in form of title. Select search field in the form of abstract. If we have just Google anything in a Google patent and we have the abstract about it, which is for the Indian patent, we can put over here. Even in the some Google, while we are doing some search in a Google and we get some, you can say the patent abstract, and we are not aware that the abstract is of which author, who is the inventor, what is the field of invention, and so on. So we can search even with the abstract also. So the abstract is there, then the complete specification, application number, patent number, applicant name, applicant country, applicant address. So there are so many fields are given to us to make our search. That means we should be reach into a particular patent because they have given all the options: applicant, applicant address, their how many applications they have filed, what is the name of the inventor, you can say address, what is the country of it, if it is having a patent, already granted patent, if we have the patent number, we can also go into it. Then if we have the subject, invention title, application title, so there are so many options are there, any one of them, and whatever the titles available with us, we can enter over here, and in the bottom there is a, you can say the captcha code, we'll go into it and search it. So to get a particular patent, I'm telling you an interesting story. Okay. One of the interesting stories is that this is visible.
Yes.
This is a granted patent. When an
No,
application
not visible.
not visible.
No. You can share it.
Okay, I have to share it.
Yes, yes.
Now visible?
Yes, now visible.
Yes. Here, to search a patent or a patent application in our Indian side, I'm giving it a very, very simple example that this is a format, or you can say the certificate of a granted patent. After the filing our applications, the Indian Patent Office provided us this certificate that your invention is granted. So here in this, I'm telling you the story. This patent is granted to a lift mechanic. He is a Mumbai-based mechanic. He has a very good hand of cleaning. You can say that the lift, as well as you can say the panels of the elevators. And because he has an idea of his experience, you can say the experience holder, that how to clean the rust from the machines. Somebody told him to go for a patent file. He has agreed and he filed a patent application. Here, if I zoom it, you will see that this patent application, in this granted patent, you can say the certificate, you will see that the patent number is mentioned. Here the application number is mentioned, file, that the date of filing is mentioned, and name of the patentee. When a patent granted to a person, then that person is called the patentee. This invention is given, this is mentioned over here, and at the bottom you will see where we have this the a seal of our Indian Patent Office. You will see that the date of grant, that the date of grant is mentioned at the bottom, that is the 25th 4th 2022. Okay, so now we are taking, because this is a person, we cannot say he is not a mechanical engineering, but he is having an invention for cleaning, you can say the devices, the rust clean, he has you can say form a rust cleaning devices, and this device is very, you can say the useful, so he has got a patent for it. So with these, you can say the information, we will search this into our Indian Patent Office search site. Okay, so here I am taking all the options, we can take it, but here specifically I am taking the number of patent, because now this is with us, so we'll take a patent number. So the number of this one is, we are now again, you have seen this patent application, that is the patent certificate, all the things you have seen. And one more interesting thing you see, that this application was filed on 4th November 2020, and this was granted on 25th 4 2022. So this was highly appreciated that being a lift cleaning man or lift maintaining man, he has got a patent just one day before our IP, you can say the World IP Day. So this was highly applauded. This one, the work of this man, and people have encouraged that the how encourage the peoples to file a patent application, because if this man can be filed, then there is a, you can say, the scope for everybody to have the innovative ideas, right?
Yes.
So now again we are going to our this
patent number.
Patent number.
So we will take the patent number and we can search that there how
Yes.
whether this is coming or not. We can.
Yes, we'll go for it.
Yeah. Yes. So that we can. It will be.
Again, I am going into. We'll go for one more time. This is our. Is it visible now?
Yes. Yes.
Yes. Again, we have this Google page. Here I am going for the IP India. Okay. Again,
Yes.
we are going to the official website. In this official site, we are going for the public search. In the public search, we have this patent option.
Yes.
Here I am clicking. This will take it to our new window. And here you will see the second in pass is our Indian Patent Advanced Search System. Here we have the two options. Whether we are going to search a published patent, a published application, or an application which is granted. Okay. So here we have to click it. If we are not sure that the application is granted, then we go for a published.
Okay, and so means here when we are searching, then both will come together. Like both will come together. If we will not click here only granted and all these or only published, then both will mixed up will come. So it is difficult to understand whether granted or not. So better if we can segregate here also only granted, then only granted patent will come. Or if we will make the published, then published will come.
This is applicable when we have filed a patent application and we want to check the progress of our, you can say, the application status. Under that, we'll click into the published one.
Yes.
Right. And when we are sure, we are just going for the invention is granted and we want to get the details of that, you can say the patent. So we can go for the granted. So here, as we have just seen the example of the liftman, yes, which is a granted patent. So I am clicking over there.
Yes.
I will go to click the grant. Now here, as we are not aware, as we are we have it the, you can say, the patent number of that one. So we'll just go into this, you can say, the left side and scroll down, and there you will see that the inventor patent number is mentioned over here.
Yes.
Okay. So here in this column, I will write the patent number. Yes. So just I've shown you the patent. The number of that one is 395308. This I mentioned over here. Only I'm just giving here the patent number.
Yes.
When we are with the patent number, I just give here the patent number. Then we'll put this captcha
Q47HA.
And we go for the search. Because we have the patent number, so directly we are getting, you can say, the information of this.
Yes.
This type of window will be displayed. Here at the left, you will see that the application number. Now, what is the title? A rust cleaning device. Application date, status is granted, and application status. Here we can click into the application status when we want to see the documents attached with this, you can say, the application. So here I will click into the application status, or even we can click into the e-register, because this one is a granted patent. So it will registered in our, you can say, the patent office patent granted patents register. So I'm clicking here into the e-register. Okay. So when we click into the register, we are getting the legal status. That means patent is in force. Due date, what is the next remove? You can say the renewal date of it. Here you will get the patent number, its application number, type of application, that is a natural person has filed, the date of patent, date of grant. This is a very important date. Date of patent. Generally, people have confusion that the patent, the date on which it is granted is a date of patent. It is not the patent. We call it that the date on which it was filed, or date on which we have claimed the priority. because it could be you can say some other country's patent application. So the date of filing or our priority date will be the date of patent, and the date of grant is that. So the 20 years exclusive right holding a patentee is going to get from this one, 20. That is a 4920. And from this date, after 2 years, you can say he has to pay the, you can say, the renewal fee of the patent application when it is granted. After the completion of the 2 years, that you can say he will be able to pay the, you can say, the renewal fees for that. So here all these information regarding that the patent application. Now who is the inventor? Now here we can say the grantee also, because the patent is granted, so now it has become the grantee. The name Mr. Bale Satish Lakshman, along with Mrs. Bale Jyotsna Satish, they are the natural persons. The address is mentioned over here, and name of the patentee and granting patentee is the same thing. Here is, you can say, that details again about its address. Here is the address of service. That means with the help of the person, which is called the patent agent, this application was filed, and so the address of that person is mentioned over here. And this is, you can say, the renewal chart. So as I say that this grant is for the 20 years. The patent is granted for the 20 years. So from third years to 20 years, this, you can say, the chart is mentioned over here, and accordingly the information of that person, that whether he has renewed, his renewal is pending, that will be mentioned over. So this I just give you the one when we are aware with a patent number of it. Again we are going back, and we can go into the application status. Is this part is, I think, clear? That
Yes.
when we have the application patent number or we have the application number, we can get the information of it. Because it is a registered patent, so we'll check its status in the e-register, or we can go into the application status. When we go into the application status, all such things about it is mentioned over here, and in the bottom in the application status, it is displayed granted application and its patent number is like this one.
Yes.
Along with that, we can see here the documents which he has filed to get this patent. Okay, so we'll click over here, and here we'll see that these are the, you can say, the forms or whatever the communications he has done with that. So all these are enclosed over here, and here you will see that I shown you the, you can say, the granted patent certificate. I will click over here. The same, you can say, the patent,
Yes.
granted patent will be displayed over here. So this is the way. I'm going back again. This was, we have shown that the number is that this is valid for so and so. Here again we can see all the, you can say, the abstract. Here we can say that he has filed the form 1. I was able to see when I was saying about the patent filing procedure, I said the relevant form 1, form 3, we can say the form 9. He has filed the form 9, which I showed, which I told you that this is for the early publication.
Yes.
So early publication. So with this, we can say we'll get the maximum information about how to search, a complete search of a granted patent. In a similar way, we can search for a published patent. We can see the status of it, and as per the requirement, we can go for it. Okay. The various, you can say, the documents, like all the forms, what are the communications with the, you can say, the patent office, when we are getting our examination report and all that, we can get it from here. It's a very good example because it's a, we can say, a man who is not so educated but is having a technique to clean, you can say, that to make a clean dust proof, you can say, the devices, he is getting a patent. So it's a good example for us. Again I'm going back. Again I'm going into the patent search option, and here we can reach into the, you can say, the our search site. And now instead of that, you can see the patent number. If I'm just writing here the title, I'm writing just the title, and I'm just writing the name of the, you can say, the inventor, then to how many informations we are getting. Okay, so I'm just writing cleaning, a rust cleaning device. A rust cleaning device. And here I am writing here because I am aware with the name of this inventor, or if we are just going for a rust cleaning device and we are just going for the granted patent, and here I will write the CAPTCHA. Is it O or 0?
This is O.
O. O F
H
DT.
DT.
Right? Then we see, is there information? Let's see. A rust clearing device. If I'm just writing the title of it, we are reaching into the same steps. The same application number, the date of filing, a granted patent. So even with the title, if we have the specific title of this, you can say the invention, we can reach into that application. Again, I'm going back and okay. So now we'll go for this graphene sheet.
So we'll search with a title.
Title with the title, and here we are specifying that you can say the time also, from 1st January to today. Just reference sheets. We are going for this 0107Y. Let's see, we are able to get it some information. You will see now.
Yes. So we can also take one more example like title. If we put, then we can also get so many patents, whatever the patents available on that date basis, we can get all our Indian patents.
All our Indian patents. These are the applications numbers, which is to 14 numbers. You will see that the date of applications, all are the published one. Yes. And here in this, you can see just like for learning. This is the first one. If I just go for the application status, so we'll get it about this one.
Yes.
What is the title? That application.
So
who is the applicant?
Awaiting the examination means it is only published.
It is only published.
It is not granted. So we can understand also whether the application is granted or not, yes. or only published. That also we can understand by this. So this was, you
can say this flow, that box filed, that is cleared, green signal, RQ request is filed, it is published, and these steps, that is under examination and disposed is waiting.
Yes.
Okay, so this is the way for searching or get the status of the Indian patents.
Yes, so we can search by, we showed two examples. One is by patent number, how we can search. Another is by also only title, any whatever if you have some inventions, then based on your invention, you can just search with that subject, whether patents or Indian patents are available or not. By just typing the title, then also you can able to understand that how many patents are available still yet, how many are published, or how many are just are granted. So all this information you can get from this website, IP India. IP India, IP patent.
ipindia.gov.in. ipindia.gov.in.
Yes, so this is the official website for searching the patents.
This is the official site.
Yes.
We can go into the home page. This is ipindia.gov.in. This is the official site.
This is the official site, and then the public search, they can able to find out all the different types of patents, and they can either they can get application number, or they can use patent number, or they can use the title of.
Even with the title, what are the information is they want to get it in a field according to their field of invention. If they are willing to file a patent application in India, they can go into the public search and put a query according to you can see the field, what are the information it is available with him. Okay, so they will get the information. Title over here, some information about it. Okay, so this is, I am just giving you the way we can search the patent in our Indian site.
So in this side, in this side, if they can either they can put the title or they can put the patent number, then they can easily search the Indian patents. All the Indian patents, they can able to find it here.
We are able to find all the Indian patents into
whether it is published or it is accepted, based on that granted, or it is published, that they can all the information they can get if they
all the information we can get it.
And
we
also
have
they
seen
can
into
search either by patent number or by application number or by title. Any of
or
one
by
they can
title.
any of one
Title.
they can use to find out the Indian patents by using this site. Or similarly, also for other countries like for US or UK, also different sites available, or no, that from Google patent only we can
No,
able to
no, no.
find
We
it.
have the different sites for
Okay.
country wise, for
So for
filing.
country
We can
wise,
say
there
for
are
the search,
different sites. So,
different sites.
so then today we learn that how we can search the patent, Indian patent, how we can search from the particular specific sites, and also how we can know the status of our of submitted patents. So this is for the Indian country. So next lecture onwards, we can understand about the different countries, what are the different sites available for US patent and for also UK patents and all. So thank
Yes,
you very much
definitely.
for giving your time and to explain all in detail. So hope it will be very helpful to all the viewers. So the viewers subscribe this channel so that you will get earlier notification when we will upload the next videos on the for other countries, how we can search, what are the official website for other countries, and also what are the official website to search for US patent and UK patent. So thank you very much for watching. If you have any comments, then you can write down on the comment box. Then definitely at the end we will also make some live session so that it will be helpful for all the viewers. And at the same time, if you have any comments, you can also write down your uh, comment on the comment box so that we will try to answer on our next discussion. So
Thank
thank
you,
you
Dr.
very much.
Apan. And